సెల్ అది ప్రియదర్శిని పెట్టు సెల్ ఎంతటి మెన్షన్ చేస్తాం ప్రియదర్శిని అంటే 73 ఇదేమో సెకండ్ ఐటమ్
Page 2, 50 to 90. Page
By 2 weeks time from petitioners.
Yes, sir, 2 weeks.
Page 10, item 116 to 129.
Item
128,
Yes.
requesting 2 weeks time.
122 and 123, my lord.
Yes, sir.
There is a back term item, that would be 2A.
122, 123.
Yes, sir.
Post along response, so and so after 10 days.
Such a place.
Mellots item 127 mellots.
Yes, sir.
Strictly take it out 2 weeks mellots.
Such a place.
Just after 2 weeks.
Apply.
Page 11, item 142.
My lord, item 142,
Yes, sir.
this is Zakir Ali Danish appeared, my lord, not
What is the name of so and so, so and so, so on the face of Arvin of the data? Yes. Yes, sir.
Item number 127 says in the week clearance.
Lordships, kindly I have print KC Venkat Reddy, Standing Council for Police Housing Corporation.
Which one, sir?
108 Lordships.
Yes, sir, 108.
My name is not printed, Lordships, KC Venkat Reddy, Police Housing Corporation. Kindly I have printed and post 2 weeks, Lordships. Post on.
KC Venkat Reddy.
Yes, Lordships.
KC Venkat Reddy, Standing Council for Police of the
Well, it's subject to lordship kind permission. And bringing your lordship director to close the matter today. There is the urgency expressed by special GP. Matter pertaining to the tender bill.
Tomorrow. Day after tomorrow. Yes, sir. MFMA government is Yes, sir.
Item 2 is Mahendra Reddy.
Yes, sir.
I am appellant melot.
Yes, sir. Enhancement 3 to 15,000, sir. At the rate of 10.5. Yes, sir.
Item
अच्छा
3,
प्लेट.
What clear out?
अच्छा प्लेट.
item 3,
Here are certain conditions imposed by for payment of amount 3,70,005, 7.5 years.
item 20.
$55,000 to $92,000, sir, enhancement. Yes, sir. Proceed, sir. 10 minutes, sir.
Item 7, Syed.
Please wait 10 minutes, sir. Yes, sir. Yes, ma'am.
I have bought the vacant premises, my lord. I have physically visited it, and also then with the permission of the owner, I have raised the ACC sheets and then got it registered in June, my lord. And then
Yes, my lord, the dues of previous, and one more service connection, the same reset, my lord.
They have to pay.
They have to pay, my lord.
My lord,
My counter, they require the counter.
my lord, I have taken a vacant premises, my lord. There is no question of service connection prior to this at all, my lord.
That was
I-
connected for non-payment, my lord.
Total is 66,000 rupees.
My lord, I haven't, neither me nor my previous owner has applied for such service connection. my
File out
lord.
noted, yes, sir, the council for the respond, Arvin already. For filing counter list of 2 weeks. Yes,
Item 8, after your pickup, are Mahendra Reddy.
yes, sir. Yes, sir.
Civil disputes are there, my lord, that's why they.
For permission granted in the year 2013, sir, they have to complete the process within 3 years. 20th March 2015. Now they are finally seeking a direction. Yes, None appear for the petition list after 2 weeks.
Item 9, company without
Yes, sir. Both the matters. Both the matters. List after 2 weeks. Yes, sir.
item 10, please, Senator Palmer.
Please, my lordships.
Yes, sir.
The entry petition was returned on 30/10/2023, my lord.
Yes, sir.
I filed the entry petition.
Which one doesn't road, sir?
Yes, sir, my lord, 860/34 of 2023, my lord, but written, my lord, verified, my lord, today, my lord, candidate
Page one, verify. And post telephone sound is also list day after tomorrow.
much of
Yes, sir.
motions.
Yes, motion list. Yes, sir.
Item 11, Ramesh Taylor, people with you.
Millards, last time also Millards, because of absence of the GP, it was posted today.
Yes, sir.
And
Yes, sir. Because of the comes for respond GP first. So on so GP for women and welfare. Day after tomorrow, the motion list.
okay,
Yes.
Item 12, please, Shiva Reddy, Deputy Social Welfare.
right.
Yes, sir.
This petition is challenging the action of respondent in non-acting upon my representation, and moreover, there is a irregularity in the
Yes, sir. What is?
allotting the supply for
Who is for?
Proceedings issued by the third respondent is charged.
yes, ma'am.
Part in this matter, district collector issued the proceedings. Tenders were awarded,
Who is for district collector?
government has to have the question.
Tomorrow.
Not tomorrow, the notification 47/23 challenge in this matter, we have to get to the counter.
Sir, they have quoted 250, someone to be quoted 270.
Yes,
The clear violation, yes. Day after tomorrow, the request of the council for the source respondent. GP for?
Yes, sir. On consideration of representation, with regard to permission granted in favor of unofficial response. Page number 25 is the representation.
Yes, sir.
Lord, the suit is pending, Lord, from 2007. Earlier, I have submitted, I have sent a notice to RERA. Page number 27 is the initial notice issued.
Yes, sir.
After that, Lord, no action was taken. Then, Lord, page number 25 representation was made. All that I am seeking, Lord, let this representation be disposed of by giving all the parties due notice. Either way, Lord.
My lord, I beg to represent the respondent number, the unofficial respondent, Phoenix Space, my lords. In this matter, my lords, we'll file a detailed counter, my lords. The lordship may have it anytime after a week, my lords. We'll file a detailed counter. Your lordship may pass orders, my lords.
Lord, I am not seeking any rights to be agitated in the writ petition. I only want disposal of this writ petition.
Who has to cancel the permit?
Lord, I am not seeking cancellation.
My lord, the impugned order is also not filed, my lords. The
Yeah.
permission which they seek to cancel is not even filed.
That has to be stated while approaching, while giving permission. Lord, that was not,
Sir, who has to cancel the permission granted by MCH?
this is not MCH. The second and third respondent for the appropriate authorities, that is TSHC. Lord, they have given permission. Lord, I am
They
saying,
have given permission under
Lord,
which
the,
act? Which act, sir? They have given permission for construction of so and so.
yes,
Under which act?
Lord, this is a separate area, Lord, it is notified. This is in TSHC limits, Lord, Gachibowli. Lord,
Municipal corporation doesn't have any power of
Lord, in these type of developments, Lord, they are the appropriate authorities. In these type of development, where separate area is earmarked, Lord, the authority will come into play.
It's not in the jurisdiction of municipality.
It is in the jurisdiction of municipality, like, Lord, the lordship may, where,
My lord, this does not fall within the jurisdiction of a regular municipality, my lords. This is an industrial area local authority specially notified by government order of the industries department, my lords. This the urban local body in respect of that particular area, which is specifically demarcated and mentioned in the GO, is TSIAC, my lords. For that, there will be a zonal commissioner to that effect, my lords, and there will be the competent authority to issue permissions, my lords.
we will have zonal regulation authority, my lord, to overview the developments, my lord, which are done within the local.
Even the impugned order is not filed. It is so the permission which they so seek to get it cancelled before your lordships is not even filed before your lordship. Let them file
But I
it.
am not seeking any positive direction in my favor, my lord, in this, all that, my lord, I am seeking, let them verify my representation. If there is anything in my representation,
Yes,
let
sir.
me
Always
take action or
we are seeking the disposal of the representation direct response to it. What do you say?
My lords, I will not be able to say anything if your lordships are directing the authorities to consider representation, because it is their right to get a reply, my lords. Let them, your lordship,
let all the parties be put on notice, let them take appropriate decision, either accepting my contention or rejecting my contention.
no, we reject the contention, my lords. We do not accept that we get the title from them, my lords, even from the contesting parties, my lords. Your lordship may direct the authorities, we have no objection to that, my lords. In fact, my lords, the proper authority here.
Want to convert this court into a civil court, my lord. All the time seeking, let the authorities in a time frame put notice to all the parties.
This was specific performance pending and you.
Yes, my lord.
Not to create any third party.
My lord, I am told, my lord, the orders are not subsisting. It's still pending. I seek right from the same parties. He also has derived the right from the same parties.
No, my lords, beg to differ, my lords. We get title from another set of vendors, my lords. In fact, my lords, the rightful party here, my lords, to put forth the correct and actual facts should be TS RERA, my lords, respond number 5. Your lordship may have it in 1-2 days, and in the meanwhile, direct them to appear before your lordships, my lords, somebody representing TS RERA, because we have already filed our application for building permission before TS RERA, my lords.
I will grant you day after tomorrow. Please come and argue before me.
Deeply obliged.
Tomorrow, Wednesday in motion list.
Deeply obliged.
Yes, sir.
Item 14, HCS, may it please your lordship.
Yes, sir.
The petitioner is aggrieved by the respondent department issuing power bills in the name of third party, even though the department has entered into agreement with the petitioner itself. The agreement is at page 13, your lordship. I am the owner of a building premises, and the power connection has a power for high tension power connection has been granted in my favor, and an agreement to that extent has been executed between the Southern Power and the petitioner at page 13. In the 22 itself, September 22. But since then, the power bills are being issued in the name of third party, who happens to be an earlier lessee of mine. And that lessee has vacated the premises in 2020.
Yeah, the connection is same connection by initial. My lord, once the property was leased out, there, my lord, the lessee was, my lord, granted certain benefits, my lord, because it's a software company. Wherein, my lord, because with the service connection in their name, my lord, they have to obtain a certificate from the department saying that they're entitled to the power tariff, lesser tariff. That was done. Then, my lord, what they did, it has to be in the name of the SPE captain. They did not change it. It was in the original. So, my lord, we raised a demand against them. My lord, even we are saying because it is against service connection is same. Only person and or claim can be only against service connection. The demand is there. It is not disconnected. Now utilizing the power. Now, my lord, I'll file my counter in this.
May I submit this, your lordship? Just for a moment. May I submit this? Having entered into a specific agreement, power distribution agreement, power connection agreement with me in September 2022, the submissions made by the learned counsel are not tenable. If you have certain grievances against my earlier lessee, tenant, who vacated in 2020, you should have not entered into this agreement. Having entered into this agreement today, I am placed in a situation where I happen to be in the premises, I am utilizing the power, but I am paying.
When do you want, sir?
Well, 2 weeks. Why 2 weeks, sir?
1 week, your lordship. 1 week.
And the request
Take some time, my lord. 10 days.
10 days, and the request of the council will respond or we know the list after 10 days in motion list.
Obliged.
It's matter. I filed a implied will. They make allegations in the writ.
I am the petitioner,
Doesn't
my lord.
make me a party.
I am petitioner, my lord.
Yes, sir.
There is no chance of interpretation because that Kolan TSHC did not have any title, right or interest in this.
ఒక టైటిల్ లేని అర్థం కోసం ఇంప్లీడ్ అయినారుగా
4-5 రిట్మెంట్స్ సార్
Already they
బెస్సకి లేదు బైక్ లేదు అందాం అనుకుంది
yes, my lord.
వాళ్ళకి లేదని చెప్పడం కూడా ఇంప్లీడ్ ఆర్డర్ చేయాలా వద్దా
I filed it today, my lord. I've taken up.
చెప్పండి సార్
Earlier already removed, my lord. This.
ఐ డూ అగ్రీ సార్ ఎక్స్ కి లేదు బ్రోకర్ స్టాండే లేదు అనుకుందాం
Yes, my lord.
అది లేదని చెప్పడం కోసం ఇంప్లీడ్ చేయాలిగా మరి ఆ ఇంప్లీడ్ రావాలిగా ఇప్పుడే సార్ మీరు
Today morning, I filed.
ఏ సార్ వాట్ ఇస్ ఇట్
There are about 4 writ petitions pending between the parties, and police has seized the meter. The civil
purely civil dispute development agreement, they say is contravened.
List all petition. ఇక్కడ వేరే వస్తుంది ఇవన్నీ.
My lord, item 85 today, my lord, with regard to same.
Item 85.
My lord.
Yes, sir.
86 hours.
10 days to date this change.
Hello, short passover, my lord, item number 18, senior counsel appearing. Short passover, my lord. Item number 18.
8/2014,
Acha,
WP number 30714 of 2014. The other repeat does not say that no further orders are required to be passed. Accordingly, repeat is dismissed. And repeat is closed. Yes, Raja. Yes, sir. Yes, sir, GP. మీరే కదా ఎందుకు సర్వైస్ go through it.
I will verify.
Instructions because policy has been changed after this. And the request of the council for the respondents to verify the cosmetic petition survives or not. List on Monday in same caption. I think it become infectious. Yes, sir.
Item 36, 18 hours to Babu.
Lordship, pending granted next time, Lordship, we have to verify about this.
As the request comes to the petitioner, the request of the council for the petitions for verify.
2 weeks, I also verify whether it matter and
Start after 2 weeks. Print the name of or we know that in the period of for the response card. Yes, sir.
Matter pertains to refund of FSA charges, we have to verify whether it has been disposed of in Supreme Court.
Supreme Court pending, matter is pending.
FSA.
You will also verify.
We'll verify and get.
The request of the council for the
3 weeks.
petitions as well as the respondent to verify the cause request surveys or not. Juncture, the council for the respondent or whether it is submitted that the
Not granting land, but the only thing is Milad civil court case is.
My lord, I am representing Mr. Hari Sridhar in this matter, my lord. My lord, Mr. Hari Sridhar said this, there are subsequent to the writ petition, there are other developments which have happened, which have to be brought on record for this honorable court to adjudicate the matter, my lord. May kindly grant us time for 2 weeks, my lord, to bring the additional papers, my lord, with all the subsequent developments.
Sir, this is only to the extent of consult the representation dated 1/8/2014.
Yes.
Only dispose of the representation, sir.
No, my lord. No, my lord. There are subsequent developments also, my lord, that they have filed certain suits. The suits were also dismissed. They have no right at all whatsoever.
The main prayer itself is shows that writ of manam also declaring the action of the third respondent is not concerning the representation of the petition dated 1/8/2014. Submit the grant so and so, so and so. And that they are directly concerned.
The grant itself.
What you want, sir?
Yes, the grant itself is based upon the GPA being given to my lord, a particular.
The main prayer itself is only dispose of representation, sir. Find out the cause of petition. I don't think so. After that, policy has been changed.
Yes,
Yes, sir.
yes, lord. The very right is based upon a GPA, my lord, which was.
Second, sir, repetition main prayer dispose of representation, sir.
Yes.
Infrastructure చూసుకోండి సార్ ఏనండి.
Yes, I'll do it, my lord. It may kindly be posted next week, or at least, my lord. I'll inform Mr. Hari Sridhar about this.
First, GP for Mines and Geology as well as a request made on the Hari Sridhar. List on Monday to verify the cause and petition survives or not. None appear for the petitioners. M. Raman. Yes, sir.
Much obliged.
Yes, sir.
My lord, in this, the blacklisting issue is for about 2 years. This honorable granted interim stay. The 2014 matter, she may take care of, may not be because, I'll verify by Friday, your lordship.
The request of the council for the response to verify the cause and petition survives or not. Jakir Ali Danish with the name of so and so for respondents. The list on Tuesday. 17 years.
133 and 134 also same issue.
133
And 134.
and 134. Put the name of so and so.
Same issue.
Yes, sir.
Obliged.
Yes, sir. Yes, sir.
I need to file a, not there in file, verify.
Yes, sir. The request of the council to respond ROE of the after 2 weeks for final counter. Yes, sir.
Granted extra motion.
In this also we have to file, not file a counter, according to the record.
Request of the to respond to corporation ROE of the list after 2 weeks for final counter. Yes, sir.
This also my lord will put a counter, and verify it.
For counter after 2 weeks, as request of the ROE of the comes to the respond. Yes, sir. Yes, sir. What change చేయాలి
My lord, in this, you are
for the petitioner.
yes. My lord, not for the petitioner, my lord.
Why it was shown as most for the petitioners? Or below the day? ఇప్పుడు మీరు ద్విపాత్రాభినయం చేయాలని చూసుకోండి.
My lord, counter is filed by us. My lord, I think that and another council.
No, sir, Constable R. Vinod Reddy, you are not R. Vinod Reddy? Yes, you filed a petition. చూసుకోలేదా?
Sorry.
నాకు రెస్పాండ్ ఎవరు కావాలి? జకీరాని ధనుష్ కావాలా? లేకపోతే ఉమాదే రావాలా?
It can be closed, my lord. If your lordship will see. Matter can be closed, there's no problem.
Also for the petitions, R. Vinod Reddy submitted in view of the Indian model granted by this court on 26/9/2014 in WPA.
So the next week.
Filed our counter, vacate also.
Yes, sir. Emma,
Kindly next week.
as request of the council for the petition. List after 1 week. Wednesday. Yes, sir.
Kindly grant a fixed time.
2 weeks.
Put the name of R. Vinod Reddy in the face of woman already list after 2 weeks. Yes, sir. You appeal for the petition, yes, sir. You think survive? We will survive, no, sir.
Not ours. End of it.
Yes, mining. Keep figure.
Lord, I will verify it.
Verify, sir. మీకు ఇందులో పార్టీగా లేదు. Yes, who is for the revenue? Run it. None appeal for the petitions. Yes, madam.
May please, Milord. Milord, district petition is filed, Milord, questioning the proceedings of the Assistant Director of Mines and Geology, Milord. Written a letter to the Tahsildar, Milord, for to hand over the land, Milord, where the petitioner established a crusher, Milord. That is later dated 19/9/2014, Milord. Milord, facts of the case like this, Milord, petitioner before Lordship is the granted a crusher permission, Milord, which is for period of 5 years, Milord. It is granted in 2008 up to 2013, Milord.
I think service, madam.
Service, Milord, because there is a suspension, Milord. Milord, Milord, that Milord, the proceedings are questioned, this honorable court suspended, Milord. In the meanwhile, Milord, the department has issued a demand notice, Milord, questioning that Milord petitioner filed appeal before the director, Milord. Subsequently, Milord, in the year 2023, Milord, appeal was disposed of, Milord. Advised the petitioner to file a revision before the revisional authority, Milord. Now the petitioner filed the revision before the first respond, government, my lord, that is pending. My lord, the only fact for consideration is that, my lord, the petitioner established a crusher, my lord, under the obtained a permission under mineral dealers rules, my lord. It is valid, my lord, 2013. Thereafter, he filed the renewal application. My lord. Renewal application is pending, my lord. Pending renewal application, they submitted the.
Policy has been changed.
Vivo 26 million.
Policy change.
No.
21-3.
GO regarding 26 grant, my lord, lease, granting lease, my lord. This is not the grant of lease, my lord. It's only crusher, my lord. He purchasing the material, raw material from the other lessees, my lord, crushing the material in his unit.
Lord, I will verify.
Verify and file your counter.
2 weeks time.
No, count file.
Counter.
Counter file, my lord. Counter file, my lord. Monday week.
14, yes. Yes, madam.
But the
Monday
petition,
is Tuesday, 14th Tuesday also.
Yes.
Yes, sir.
and some of the petitions is madam, my lord. Sincere apologies, mentioned last petition.
Anything survives?
Yes, my lord, service, my lord. Kindly after 2 weeks, my lord, we'll take the
Regarding the service connection,
Yes, my lord.
provided law.
Provider?
Well, mutation was detected in favor of the unofficial expansion that is being channeled.
Station ballot now. Yeah, your lordship directed to make a press representation by presenting all
2
the.
weeks, my lord, we'll get instructions.
1 week
There is also
Hyderabad.
no minutes, Hyderabad. Yes,
1 week.
ఎక్కడి నుంచి పిలిస్తే మీ క్లయింట్ వినపడదు కూడా ఇక్కడే.
yes, my lord. 1 week, my lord.
Constable the petition.
Next month.
It's on Thursday. To ascertain the cause and retribution surveys are not from his client.
Yes, my lord. Bless.
మనం కూడా అక్కర్లా అక్కడికి పిలిచి పంపిస్తాం.
Bless.
Police for the, any lordship, sir. We haven't gotten instructions from client, lordship to concern required represents that he is unwell and we could not trace out the client himself.
Yes, sir.
Maybe post after two days, your lordship. We posted day
Does
after.
not survey anymore.
Tender notification, sir.
Award work. Yes, 2011-12.
Anyhow, at the request of the constable, the petitions to ascertain the cause and retribution surveys are not.
Thursday.
List on
Thursday.
2 weeks.
Obliged.
Yes, sir. Actually, dismissal.
My lords, I'm for item number 52, my lords.
Yes, sir.
My lords, may I seek lordship's permission to take up this matter next week, my lords?
Yes, sir.
Just short date, my lords, 52, short date, next week.
Yes, sir. Tuesday at the request of the constable. List on it.
52, deeply obliged, my lords.
1 second. 50, 20 years, 50. Who is for the petitioners? This was the non-prosecution. Yes, sir. This was the non-prosecution. Yes. అది పిలిచాం కదా అయిపోయింది కదా 52 ఇచ్చాం కదా మంగళవారం ఇచ్చాం ఎస్ సార్ ఎస్ సార్
Lord, we have argued this matter the other day, my lord.
ఎస్ సార్ వాట్ ఈస్
Yes. May I try not to? Well, the council only shown page number 30. Our petition, first petition, we are talking 19516 of 2023. That it is order of the documents we have received. Other documents, page number 30. There is copies of previous work orders, similar work, certificate showing minimum 3 years of experience with TSHC, similar type of work on any one of the bound means, till regulation, technical skill, etc. is required. Whereas page number 62, there is a horizontal.
Yes, sir.
Other documents.
Yes, sir. 62.
Other previous work or similar work certificate showing experience in similar type of work, any extent more, it means self-declaration of relevant experience. Here the 3 years of experience are being removed by way of Punjab. But now my law friend is relying upon 3 years. In spite of having knowledge about the Punjab.
I filed the corrigendum, my lord.
Anyone can file tender. Even though doesn't have any experience after it.
But he has to show, he has to self-declaration of relevant technical skills has to be shown.
Yes, sir.
It is. May I submit?
Why that much of concession given by the authority?
Not just to invite the global tenders.
No.
Relevant technical skills, self-declaration itself is enough.
Similar.
Not necessary for any authorities.
Similar.
Not necessary for any authorities.
Yes. Their self-declaration should be declared.
Self-declaration itself.
Self-declaration as per tourism is approved by the higher authority. It's not for this purpose of only this thing. It's already generally in other gender notifications also it would say.
That's an admission of arbitrariness, my lord.
It is not.
I cannot help that.
It only yes for the purpose.
It's an open.
This tender purpose only. May I have gotten second petition?
One second, let us confined to the
Yes, sir.
first. Yes,
These pillars, they are category set tender, page number 62.
yes, sir.
Other documents. This is the corrigendum. Well, prior the tender processing started, this corrigendum issued and then they have submitted in accordance with the corrigendum only. May read by counter. May read by counter.
Yes, sir. Yes, sir.
One second.
Counter.
Counter. Page number 8.
Yes, sir.
As a reply to number 13, 14 of the petitioner, the TSHC stands general terms and conditions.
One second, page number?
Page
number 8.
My counter. Page number 5 of my counter.
Change.
As per number
2 to 5. Huh?
4 to 5.
Yes, sir, please.
Paragraph 8.
Yes, sir.
I submitted in reply to number 13 and 14 of the update as per the TSHC standard general terms and conditions. The tender should be experienced in executing a similar type of work at least once in the last 6 financial years, including present financial year. In this regard, it is submitted that the corrigendum 1/5/2023 was issued to the original date wherein the similar experience of any type of bone mills was informed would be considered. In fact, the corrigendum was issued in the interest of organization. It is to submit on NIT 18 of 18/4/2022 was published e-procurement on 28/4/2023 and the corrigendum was published on Monday without any delay or without any redetermination. As per the tenders of tender, TS reserves the right, it is in general terms. Accordingly, corrigendum was issued to consider the work experience in any of the XRP type 4 mills due to reason stated in the paragraph.
Self-declaration itself is sufficient.
Paragraph 2 is less. And this only type of experience. Can you see the page number 22 of the petition?
Yes, sir. Red petition?
Red petition.
Yes, sir. Yes, sir.
Type, tender type.
22.
22. This is notification, tender notification filed by the petitioner. Tender type is limited in tender, limited in nature. Page number 22.
Okay.
Column number 7.
This rule is applicable to the extent of this tender only.
This tender.
Why?
Limited tender, it's limited tender, single part bid, and price bid only. It's only price bid. In another rate petition classification, the other types of the nature would be there. in this.
No, my doubt is, I'm not saying anything about the rules framed by yourself. I'm least bothered about that.
These are not rules.
Whether the rules or conditions are applied to the all players fairly, equally, or the point for the consideration.
Exactly. It is not in this tender only. Pertain to the repetition panel.
It is
Put all the players.
1951.
It is a players.
Milas, in this Milord. Already I have started Milord in this Milord.
My lord, it is not that simple, my lord.
Let me finish Milord. In between, if we interferes like this Milord, I can't hear you.
మరి ఏం అక్కడ నా కోట్లు మీరు సెవెన్ ఆర్బీ తీసుకోవచ్చు చెప్పండి పర్లేదు ఈ రొటీన్ డైలాగ్ మానేద్దాం
Otherwise, but sir, he is going to interfere. I wanted to do.
ఇటున్నా చేసే పని అయితే లేకపోతే కానీ నా కోట్లు అవన్నీ
నేను అటు ఇటు రెండు ప్రాక్టీస్ చేస్తున్నా సార్ ఇప్పుడు.
సార్ రూల్స్ గురించి కాదు, ఆ రూల్స్ అన్ని కూడా అందరు ప్లేయర్ కి
Yes, Lordship. If it was 3 years experience, Milord, even the petitioner also not eligible. He submitted only 2 years experience only. 2 years experience only. That was my contention. And the corrigendum is that current year he has to work similar work of our nature in the within 6 weeks of the 6 months of the district. And based on that only, the L1 and price bid was quoted by unofficial respondents far lesser than the petitioner. And work has finished only 80% of work has finished.
Yes, sir.
May I submit, my lord? My learned counsel's permission. My lord, it's not that simple, my lord. One thing is that.
Yes, sir.
And moreover, Milord, in the regard to the experience, Milord, in repetition, second repetition, I filed a Honorable Delhi High Court judgment, Milord, stating that similar nature of work, if he has any experience in regard to the other company who is in part and parcel of the their director, managing director of the property, and if he requires right in the next and his sole proprietorship is there. So proprietorship there, that experience and this experience should be construed. If that is the case, in that case, this case perfectly fixed that previous
Yes, sir.
But since I'm a advocate.
Previous company, which is nothing but proprietorship, it was not sole proprietorship, it was joint proprietorship, and the wife of the petitioner, unofficial respondent, relinquished the right, and all goodwills of the property are released to the unofficial respondent. Next, he has become sole proprietor of another. Just only names of the companies have been changed, but it's not experience of the previous person.
Yes, sir.
Similar person is there. Unofficial respondent, there are in the last 3 years, the Supreme official is there, and the present unofficial respondent is there. But proprietorship has been changed. That was the judgment passed by the Honorable Delhi High Court, and in Suraj Bank case also, similarly, the Honorable Supreme Court also
Yes, sir.
The matter also pertains to FSA charges demand of the challenging the OP. We have to get clarification because there is this has been challenged before the Supreme Court records.
Yes. Verify matter. With request of both the councils to verify the coordinate both the council petitioner, the other respondents.
Well, it's item 114 is also connected matter. So that's it.
21, sir.
3 weeks, my lords. In fact, my instructions are that these appeals are pending before the Supreme Court. So until the disposal of the Supreme Court, any claim or refund is subject to the outcome.
Yes, sir. 2 weeks.
Obliged.
Yes, sir.
Yes,
Yes, sir.
I am for the petitioner, my lord, 1 week time may be granted. First time coming.
other connected matters to be.
Yes, post along with council.
Interpret not with have been already decided matters.
Some other matters are there, sir.
Yes, well, same party I'll verify. Because with the parallel and
Just after 10 days, very first of the council is not being operated. Yes, sir.
2 weeks.
JP for the next. So it's good.
Yeah, I'm not going for the petition.
Is that I appear for respondents.
What is the name of Jackie Ali College?
I will respond in 1 month.
I have got 2 to 5.
Stop for 10 days. Yes, sir. What is the name of source? Jackie Ali College.
Yes, sir. Both the matters, they go together. Please take up 59. When it's a review application and covered by a decision of the honorable court, unfortunately, that was not brought to the notice of the learned single judge at the time of disposal of the writ petition.
Yes, sir. What is it?
Granted because the character, the writ appeal, they had filed that was.
When do you want? Why 2 weeks, sir?
This is my third appearance in this. The synopsis I have prepared. No problem.
File of it. Vinod Reddy, very good demand note.
Yeah, I have asked. I have asked.
R. Vinod Reddy.
In this matter, my lord, they filed the counter, I filed the reply. The issue is before your lordship, the petitioner was appointed as a member of the Telangana State Minority Commission, my lord, and paid the salaries to the members and chairman of the Minority Commission on par at par, Women Rights Commission, BC Commission, SC Commission, but not paid the salaries to the members of the Minority Commission, is under challenge before your lordships. Equals cannot be treated unequal, unequals cannot be treated equal. The same principle is being applied for this, my lord. Your lordship may kind consider at page 11 and para 7. I may be permitted to read it, my lord.
Yes, sir.
I further submit, whereas the chairman of the Telangana State Minority Commission salary and allowances as enhanced on par with the chairman of the TSPSC and BC Commission, but the members of the Telangana State Minority Commission salaries and allowances have not been enhanced on par with the members of the TSPSC and the BC Commission, is amounts to violation of Article 14, 16, 19, 21, 300A of the Constitution of India, which cannot be allowed by law, which is basic structure of the Constitution. Under the same discriminatory and arbitrary action of the respondent, as straightly staked down by the Honorable Supreme Court in a kitten of constitutional bench judgment from 1952 till yesterday, including in the case of Khati Running Rawat versus State of Saurashtra, which is 7 judges bench judgment of an apex court, reported in AIR 1952 SC 123 at para number 7. Punatat Tanutut Mupul Nayar versus State of Kerala and under, which is reported in 1961 SC at page 552. And the same reiterated by the larger bench of its court in the case of Ramana Dayaram Shetty, the International Airport of Authority of India and others, which is reported in AIR 1979 SC 1628 that all legislative differentiation is not necessarily discriminatory. In fact, the word discrimination does not occur in Article 14. The expression discriminate against is used in Act 15 subclass 1 and Article 16 subclass 3, and it means, according to the Oxford Dictionary, to make an adverse distinction with regard to distinguish unfavorably from others. Discrimination thus involves an element of unfavorable bias, and it is in that sense that the expression has to be Understood in this context, if such bias is in disclosed and is based on any of other grounds of the grounds mentioned in Article 15 and 16, it may well be that the statute will without more occur condemnation as violation a specific constitutional provision unless it is saved by one or other of the provisos, those articles, but the position under Article 14 is different. Equal protection claims under that article are examined with the presumption of the constitutionality stems from the wide power of classification, which the legislature must, if necessity possesses in making laws operating differently as regards different groups of persons in order to give effect to its policies. The power of the state to regulate criminal trials by the constituting different courts with the procedure according to the needs to different parts. Its territory, it is an essential part of its police power. Procedure, though differing procedures might involve disparity in the treatment of the person tried under them, such disparity is not by itself sufficient, in my opinion, to outweigh the presumption and establish discrimination unless the degree is the disparity goes beyond what the reason for itself sufficient. In my opinion, to outweigh the presumption and establish discrimination unless the degree of disparity goes beyond what the reason for existence demands has. For instance, when it amounts to denial of a fair and impartial trial, it is therefore not correct to say that Article 14 provides further no constitutional protection of personal liberty than what is as offered by Article 21. Notwithstanding that is wide general language is greatly qualified in its practical application by a due recognition of the state's necessarily wide powers of legislative classification. Article 14 remains an important bulwark against discriminatory procedure laws, and the same reiterated by the Constitutional Bench and Apex Court in the year 1961. The statute may not make a classification of the persons or things for the purpose applying its provisions, but may leave it to discretion of the government to select and classify the person to whom its provisions are to apply in determining the question of validity or otherwise or such statute. The court will not strike down the law out of hand only because of no classification applies in its face or because discretion is given to the government to make selection or classification, but will go on to examine and ascertain if the statute has laid down any principle or policy for the guidance of the exercise of the discretion by the government in the matter of selection or classification. After such scrutiny, the court will strike down the statute if it does not lay down any principle or policy for guiding the exercise of the discretion by the government in the matter of selection of classification, on the ground that the statute provides for the delegation of arbitrary and uncontrolled power of the government so as to enable it to discriminate between person or things similarly situated, and that therefore the discrimination is inherent in statute itself. And also in the Ramana Dayaram Shetty's case, reiterated that this rule also flows directly from the doctrine of equality embodied in Article 14. It is now well settled as a result of the decision this court in E.P. Royappa versus State of Tamil Nadu, which is reported in 1974 2 SCR 348 and Menaka Gandhi versus Union of India 1978 1 SCC 245, that article strikes at arbitrariness in state action and ensure fairness and equal of treatment. It requires that state action must not be arbitrary but must be based on some rational and relevant principle which is non-discriminatory, must not be guided by any extraneous or irrelevant consideration because that would denial of equality. The principle of reasonableness and rationality, which is legally as well as philosophically an essential element of equality or non-arbitrariness, is projected by Article 14, and it must characterize every state action, whether it be under the authority of law or in exercise of executive power without making law, which judgments are clearly applicable for this case. My humble submission with great respect to this Honorable Court. The commission and chairman and members were appointed in one class. Paid salaries initially saved. Subsequently, Milord, the commission of chairman was paid salaries on par at par publishers commission and BC commission, but not paid to the members on par at par TSPSC members and BC members are amounts to discrimination and arbitrary, and same is principle laid down before this honorable court. And your lordship, with great respect to this honorable court, honorable division bench of this honorable court, fortunately I was appeared before division bench of this honorable court in the case of Telangana High Court employees were not to provide a Telangana state increment on par at par judicial officers and lower court officers were challenged before honorable Chief Justice Court in T. Akaya and others case, and not paid the Telangana increment on par at par judicial officer and lower judiciary to the High Court employees were categorically allowed by relaying the judgment of Ramana Dayaram Shetty. T. Akaya and others I would submit before your lordships for kind consideration. My humble submission with great respect to this honorable court, where the within the members and commission has paid salaries on par at par BC chairman, TSPSC chairman, and members are not paid is.
Sir, who is for the respondents?
Wasting time, lordship, special government and affair person. This man.
Tomorrow.
Next week, lordship. He's not. Next week, lordship.
Who is not well?
Special government. This man.
List on Monday.
Meanwhile, that judgment also I would submit before you. Because clear arbitrary discrimination is being established in the case. Bless.
Bless.
Yes, sir.
61 is election.
Yes, sir.
It is coming for counter, my lord. So far, counters were not filed.
Also file, my lord.
Right?
Yes, my lord. Third respondent file.
The next matter.
62. Which was the embezzlement? 61.
62.
Yes, sir. Yes, sir. Social welfare.
Counter file, my lordship.
Yes, counter file.
Not received.
Yes, counter. Received సంతకం కూడా పెట్టారు సార్
వాళ్ళు ఎవరికో ఇచ్చేసారు. I'll receive my lord after 1 week.
Yes, sir.
May please. But in this, my lord, counter filed. The petition before your lordship plaintiff, my lord, filed a suit for partition.
Yes, sir.
Page number 10 is the impugned order, my lord. Page number 11 is the order, my lord.
Appeared for unofficial respondents.
Someone filed wakalat, my lord.
Yes, sir.
For respondent, someone filed wakalat.
AP.
We file counter.
They filed counter.
We have the Mr. Appropriate. Yes, sir.
This one, 2 weeks, your honor. Counter has to file.
To file counter, madam. For?
I'm for the petitioner.
Counsel for respondent 3.
Yes, sir.
In 64.
Yes, sir.
The I number 1 of 2022 has been vacated.
Can we have this matter to 2 weeks, your honor? That senior counsel is appearing this matter.
The respondent number 3 is again is functioning as Qazi, as the order is vacated, as IA is vacated.
And the request of the constable of petition list of the. We have vacated. Yes, sir.
Lordship, I am appearing for the respondent work report. 2 weeks time may be given for filing of counter, my lordship.
Yes, sir, you are for the respondents council.
Work report. 7.
I appear for the respondent number 3 home in this matter.
Yes, sir, what is the matter about?
Their grievance is that no action has been taken by the state work board for removal of the encroachers from the work property, against which they have preferred this writ petition. And they have also made a commissioner of police, who is a unit head, and he does not have any role in this matter.
Which one?
Third respondent, commissioner of police. If it would have been SHO, or else I would have not been so pushy with respect to that is concerned, right?
Yes, sir.
2 weeks time may be given, my lordship, will file the counter in this place.
From the number of adjournments have been granted by the court. So 2 weeks granted, yes, sir.
Item 66.
Yes, sir.
This, I appear for the respondents in this matter.
In this matter, the huge persons will without respecting any law. Right and left will encroach in the private lands and they raised huts and we already filed writ petition, disposed past orders and accordingly they were all evicted. There is no person now in possession of the land.
Become infectious?
Infectious.
Yes, Millard. This was argued by the petitioner on the last date of hearing. This is that matter, Millard, where new huts were implanted on the government land.
All the petitioner, all the petitioners were evicted. Now land is in our possession. We raised even fencing also.
Yes, yes.
You are for GP home.
I appear for home, Millard. Respondent number 5 and 6.
There was an interim direction in my favor. According to that interim direction, all the trespassers were evicted.
We'll close on that.
Yes, sir. Yes, sir. I filed copy of the order also that was implemented.
Yes, sir. In
By the
the
police.
order granted by this court. Also.
Agreed with the docket order passed by the London Church, for your lordship. Docket order is on page number 9.
Yes, sir.
Docket order says so, lordship. As seen from the record, VW1 was already examined and the matter is coming up for the plaintiff's further evidence. Plaintiff is directed to get ready with his evidence on the next date of hearing. The stay order passed in, lordship may kindly, I'm stressing on this point, lordship. Stay order passed in IA number 1221 of 2005 is hereby vacated in pursuance of the guidelines issued.
Oh, that's 6 months cap.
That is not the case here, Lordship. What happened in IA number 1221, earlier, the petitioner was set ex parte. So that order for your Lordship's reference is on page number 20. That is 24th October 2005. Here it was said the matter to be posted after 10 days. And the said same CRP was disposed of finally. The order copy is on page number 25, Lordship. On 25th, on page number 25. That was finally disposed on 27th June 2006. Justice P.S. Narayana garu, Lordship. I may be read the order, Lordship. It is needless to say that the parties are expected to diligently in the prosecuting the litigation. However, in the view of the particular facts and circumstances, opportunity is to be given to the parties to agitate the application in question on merits. In view of the same, the impugned order is set aside and the matter is remitted back to the learned judge to give opportunity to both the parties and pass appropriate orders. Accordingly, the CRP is allowed. So the CRP was allowed. And I take Lordships to the page number 14, Lordship. Subsequent to this, the IA was disposed of and the stay order was made absolute in the IA itself. But here, the learned judge refers to the CRP and vacates the order. The IA, which is on page number 14, Lordship, and the operative portion is on page number 16. In the result, the petition is allowed stay of further trial in OS number 7 of 2001 is granted till the disposal of the AS 3558 of 2004 on the file of
Food for partition.
Food for partition, and there was another suit, Lordship, where it is for specific performance. That specific performance suit was carried as appeal in this.
Take out personal notice or unofficial
Yes,
response.
Lordship may grant stay till then because there was stay, Lordship, in this matter. There was stay. This IA is already stayed. The IA is in the suit.
So this permitted to take personal notice or unofficial response by the court of this side. Show me that where is the stake?
To take notice on the council also.
Yes,
On the council.
the council also.
Items 68 to 70.
Yes, sir.
Reading completed, blood hearing, countless file.
Let item 68, 69 go together, Miller. 670 is the different matter, Miller. Lordship 70, Lordship grant 10 days time for reply, Miller. Item 68, 69. Miller, in this, Miller, item 68, Miller, is filed by me, Miller, to cancel the MDL license granted in favor of the unofficial respondent, Miller, without any permission in the consent of the land, Miller. Miller, facts of the case, Miller, petitioner is the landowner, Miller. He has given a land lease, Miller, for a period of 5 years, Miller. that was expired in the month of October 2022, my lord. Thereafter, my lord, land lease agreement was not extended, my lord. In spite, my lord, the department is granting a permits on a MDL license, my lord. So I filed the writ petition to cancel the MDL because there is no land lease agreement, my lord.
Next week,
Is there order granted? Order?
Yeah, both the matters are 68.
Yes.
Yes.
68, 69.
Excuse for petition.
Yes, sir.
Sir, as the petitioner, actually have given the permission for petition.
మీ లారీ గారు రాలేదా?
సో లాయర్ గారు చేంజ్ చేస్తున్నారు, కంటిన్యూ అవ్వట్లేదు సార్. సో
ఉందా?
No, my lord, there is no entry point.
సో
Millard is submitting regarding item 69, Millard. 69, Millard. Now he filed the implete petition, Millard, stating that he is engaging another lawyer, Millard, to or he is arguing. 69.
ఎప్పుడు కావాలి?
సో 2-3 days.
List on Tuesday, the request of the request list on Tuesday.
68, 69, Millard. 70 lodgement grant 10 days, Millard. I will
68, 69. Tuesday.
oblige me.
17 after 10 days.
70 after 10 days, Millard, I will file my report. Oblige me.
Please inform the date. 14th.
Oblige me.
14th.
14th.
Yes, sir.
Lordship's requesting for passer, my lord. This matter senior want to appear, my lord.
In this Williams, last occasion, last directed to file additional, last year directed additional counter by, from my owner. I could not file additional counter, my lord. That's why only time.
Much obliged.
Yes, sir.
That's interest been filed, my lord. There is an interim order. We have complied with the orders, my lord. Lordship may have it for rejoined, my lord. 4 weeks time may be granted. The petition is out of the country.
It's a subject to payment of 7 lakhs.
We have paid, we have copied that. Complied.
No problem, we'll grant. 4 weeks.
Like requested next week.
Yes.
Petitioner, but requested next week.
Yes, sir.
We have filed our request. But I filed reply, my lord, for next week.
Storm Thursday at the request of the constable, the petitioner will stand Thursday. Yes, sir. Next week, they'll come. 16th. Yes, sir.
Lordship, in last occasion, Lordship, photographs to be filed, Lordship, in this matter. Submitting photographs to this.
What are the points, sir?
May I please, Your Lordship? I am for the unofficial respondent in this matter, Your Lordship.
Yes, sir, what is it?
Your Lordship, pursuant to agreement, Your Lordships have been carrying out work, Your Lordship.
Still you are carrying?
Carrying out work, Your Lordships. In fact, this agreement was awarded by the government itself, Your Lordship, with the TSMDC, Your Lordships.
Yes, GP.
I am the sixth respondent, my lord. Today, filling the counter, just now I communicated my long friend, my lord. If he wants to argue, fast or otherwise, your lordship may kindly take it up tomorrow, my lord. We'll argue.
In fact, we also have to file.
Lordship, present status of the excavation of the sand, Lordship, in the Mane River.
Yes, Your Lordships. May I make one submission, Your Lordships? In fact, the writ petition itself is not maintainable, Your Lordships. If they have an grievance, they have to approach NGTV, Your Lordships. In fact, this honorable court has earlier granted permission to this contractors, Your Lordships, to carry out work, Your Lordships. Pursuant to which the work is being carried out.
The work to follow the procedure in accordance with the law.
No, Your Lordships. This honorable court has passed order to carry out work in accordance with the agreement and contract granted to the parties, Your Lordships.
What is your counter?
My lord, but my counter is clearly saying that there is no such violation. According to the representation made by the petitioners, the district collector directed to the concerned competent authority to give site inspection. After site inspection, Lord, they filed detailed report. I filed along with the counter, my lord. There is no such violation as contained by the petitioner. More so, my lord, the same subject matter is pending before the National Grand Tribunal, my lord.
Yes.
OA 123. The matter seized before the tribunal. Tribunal granted stay of all further proceeding with regard to the desiltation, my lord. But
now the working that,
no, against not this contractor, my lord, against other contractors. Whereas this contractor, my lord, the work is going on, my lord. But I stated so in
to this particular contractor.
My lord,
You
but
are saying
there
that
there were 7 or 8 reaches, my lord. Against other reaches, my lord, there was stay in 123, OA 123 for the tribunal, my lord. But I filed along. My lord, I filed along. I'm filing along with counter, my lord, Pune.
That NGT orders, the submission of that NGT orders were challenged before this honorable court, and this honorable court has set aside those orders and granted permission. Even that matter was challenged before Supreme Court. The Supreme Court has again remanded back it to NGT, your lordships. Now the NGT is deciding fresh matter, afresh, your lordships. Therefore, there is no stay order except in 123, wherein we are nowhere the parties, your lordships.
Is it tomorrow? So that your lordship, so please just tomorrow. If they want to file any reply formal reply, let them file when lordship convenient tomorrow.
Petition is challenging the is my right of the farmers. That is a right of the farmers.
Yes,
21.
By tomorrow, my lordship, I will office.
In fact, your lordships may see the representation. They says that I'm carrying out illegal.
Day after, you want my reply. Request of the constable respondents.
Friday.
Filing reply. Yes, sir. Yes.
Lordship, appearing on behalf of petitioner's lordship, interim order is also subsisting, lordship, kindly.
Yes, ma'am.
Interim order is also subsisting until further.
Yes, sir.
Yeah, Director General Office appearing this matter.
Next week. Reports of the constable respondent, Advocate General Office. It's on 15th. Yes.
And I'm referring in
Yes, sir.
these matters. Please take up item 77.
Yes, sir.
The petitioner is a partnership from
27.
there is interim order made and the petition. The interim order is there and the lordship can dispose it of. Let the issue, let the raise the very a simple issue. Petitioner is a partnership firm which manufactures self-designed polyfill. The certification given by the competent authorities, so that is small scale industrial, the Department of Industries and the VAT registration, GST registration, all are to the effect that it is a manufacturing activity. And the respondents also know that it's a manufacturing activity. Can you see the agreement 42?
Yes, sir.
Entered into between the petitioner and the respondents, which is also to the effect that petitioner is engaged in manufacturing activity, industrial. Can you see page 43?
Yes, sir.
Serial number 2, details of supply. Yes, purpose industry. Petitioner is being billed under LT category 3, that is industrial category. All of a sudden, these respondents inspect this, they say that it is commercial activity. The printing process is involved, therefore we treat it as a commercial category, not industrial category. And there are orders passed by the primary authority and appellate authority. Amendment applications are filed. Those amendment petitions are ordered on 22nd August 2023. You kindly see the orders passed in the material papers NH 2 IA number 3 of 2020.
Yes, sir.
At page 8 is the interim order. A detailed interim order is passed, extracting all the facts by the learned judge who granted interim order.
But kindly have a look at this factual matrix, everything is extracted there. And kindly go to page 11.
Yes, sir.
Serial number 5 minute. Two, they have mentioned the allegation stating that it comes under printing commercial activity. The point for consideration only is at serial number 5. Case is examined as here under. It is noticed that so and so by the letter number so and so. It is clearly shows that the consumer is utilizing supply for printing design of PP film rolls bought from outside using rotogravure machine and color mixers, which is not a manufacturing activity and does not
comes under LT category 3.
LT category. That is the only reason given by them. Kindly see the appellate order, which is also cryptic in nature.
Yes, sir.
This is the appellate order first, confirming the primary authorities order.
Where is it, sir?
This is what I have read is appellate authorities order. Divisional Indian.
Yes, sir.
Then page 14 is the primary authorities order.
Yes, sir. Yes, sir.
And in this also same, a bold allegation is made to the effect that it comes under commercial activity. And kindly see the explanation submitted by the petitioner in extenso, which is on page 23 of the main paper booklet.
Yes.
Yes.
22 the order of the single case.
The main along with the writ petition, along with the writ affidavit.
This one. 18493?
No, 8904.
Yes, sir. Page 22.
Yes.
Yes, sir. Yes, sir.
Then kindly see paragraph 7. That without proper opportunity and all that this was done, that is allegation made up to paragraph 6. Paragraph 7, we submit that we indulge in manufacturing activity by rolling the film with non-adhesive colors to produce self-designed polyfilm, which is used in the manufacturing of paper plates. The competent authority, that is the industrial department, has issued necessary registration certificate. The said certificate has been issued after thorough verification of our manufacturing activity. In view of the fact that the expert and the competent body like industries department certified that we indulge in manufacturing process, the same is hallmark for the
most stretch of imagination, one can say that it's a
because competent authorities, they have certified that. And the Honorable Supreme Court also decided what is the manufacturing activity. Where by undertaking a particular activity, a new product is produced that comes under manufacturing activity. That is the decision of the Honorable Supreme Court. Products. Kindly see para 4 on page 493.
Yes, sir.
The respondent SSC herein purchased GI paper from the market, which is already duty paid base paper, and this paper, the process of printing is carried out. Here, same activity here also. Carried out by the SSC according to the design and specification of the customer, depending upon their requirement. This printing is done in jumbo rolls of GIP, twist wrappers. Bulk orders are received from Parley, which needs the said paper as packing paper for packing of their goods. On the paper, logo and name of the product is printed in colorful form. After carrying out the printing as per the requirement of the customer, the same is delivered to the customer in jumbo rolls without slitting. The issue is as to whether this printing process amounts to manufacture or not. Various so-called notices were issued so and so. The tribunal, while upsetting the aforesaid decision of the commissioner, has arrived at the conclusion that printing is only incidental and primary use of GI paper roll is for wrapping, which is not changed by process of printing. While coming to this conclusion, the tribunal has primarily relied on the judgment of this court in so and so, questioning the veracity of the said so and so. Kindly go to para 9. We have considered the aforesaid submission of the learned counsel for the parties in order to reason the principles that are to be applied for the meaning of section 2F of the Central Excise Act 1944. So and so, it is not necessary to refer to various case laws on the subject. Our purpose would be served by referring to a recent decision which was rendered by this very bench in so and so. Our reason for saying so is that in this decision, many earlier judgments have taken note of considered and principles laid down therein are culled out. The judgment in so and so was also taken note of and discussed. There is an elaborate discussion on the following aspects covering the entire spectrum. Distinction between manufacture and marketability. It is pointed out that whereas excisable goods signifies that the goods are capable of being sold in the market, the manufacture is distinct from salability. Manufacture takes place on the application of one or more processes, and each process may lead to change in the goods, but every change does not amount to manufacture. To bring the process within the definition of manufacture under section 2F of the Act, it is essential that there must be transformation by which something new and different comes into being. This is the ratio decided.
But ultimately result, as a result, the present appeal is allowed. Ultimate result is like.
Yes.
Setting aside the order passed by the so and so and restore the tribunal order.
Yes.
If that is the case, restoring the, set aside the tribunal order, restoring the. I am legal authority is that we have to accept the contention of the.
I am concerned about the ratio. What is manufacturing process? That's why I am relying on this judgment only to that extent, not the result of this case. And this is para 4, please see, para 9(1).
Yes, this one?
Yes, same date.
Yes, sir.
In the last 3 sentences, manufacturing so and so, it is essential that there must be a transformation by which something new and different comes into being. That is, there must be new, emerge an article which has a distinctive name, character of use. In this case, they are using polyfill and they are manufacturing self-designed polyfill, which is used for in the paper plates, manufacture paper plates. Not that they are using single raw material and they are carrying out any printing of it. The Lordship knows this printers are the conventional printing process, your Lordships are aware, offset printing and all. That is, this is not comparable. Moreover, the competent authorities say it is manufacturing process. They are lay people insofar as these technicalities are concerned. The agreement entered into between the petitioner and the respondents specifically mentioned that it's an industrial activity. They can't regulate this situation. Now they say, no, though our agreement is there, so we can, we'll treat you as commercial, because they want to steal more money.
Yes, sir.
That is the thing. When competent authorities say, and I am relying this judgment only to submit that what is the manufacturing process. That this is it is essential that there must be a transformation by which something new and different comes. Not that they are doing it on the plain polyfilm. They are producing self-designed polyfilm by using certain chemicals.
Yes, sir.
That is supported by the certification given by various statutory authorities. Yes.
Yes, sir.
Lord, any consumer, my lord, if you apply for a service connection, here stated which category is applying for what, whether industry, commercial,
And my lord, based on that, we initially give the service. In this case, my lord, we applied for industry. And it is duty is cast upon the consumer, my lord, to declare actually what is the activity that is going to undertake. Based on that, here it said, my lord, if industry is going to manufacture a product. It was given, my lord. When it was inspected, it is found, my lord, the petitioner just simply obtained, my lord, a sheet of paper, plastic roll, and prints, my lord, on that. Companies, whatever logo, name, so that it can be used for that. That, my lord, it's because here there is no transformation of, my lord, a product. New product is not generated. Only a plastic sheet is printing on that. My lord, because that is considered commercial act. There is no manufacturing activity at the present. That is our case. And that we have proved, my lord, we have filed in detail counter what is the manufacturing activity, what is the.
Yes, sir.
Counter, my lord, page 3, para 3. Service connection of petitioner was inspected by so. Inspected is revealed that the petitioner.
1 second. Sir, 1 second. You did petition number 18493. You are ready?
8904. I think. 8904.
8904. వేరే అందులో అప్లై ఉంటుంది లేదా Yes, sir. లేదు కౌంటర్ లేదు
COVID time, which are fine manner. Next week, it may matter.
Monday or Friday?
Yes. Yes.
When you put
Monday.
Monday, holiday.
Tuesday.
Tuesday. Please file it, sir.
Yes.
You have the copy of the counter, sir?
Yes, ma'am.
Not there with us also. The petitioner is a private limited company and is running a steel mill. Let under section 42 of the act, the respondents are obligated to keep certain open access corridor, so that private operators can use the open access corridor by paying wheeling charges. All through petitioner has been using 16.5 megawatts capacity of the open access corridor. That is 8.5 from the private companies through interstate transmission and 8 megawatts power from 8th respondent, which is also a state government enterprise. And there is an MOU between the now the acceptance last week we had this. Let there be an interim order, let them come up with counter whenever they
buy the counter.
Yes, let there be an interim order and my luncheon can order. Yes, yes, free. But it is simple, prima case. 16.5 megawatts capacity is reserved for the petitioner in the open access corridor.
You have sufficient power now?
No. What we are doing
So Friday, you have Tuesday, Friday?
You can just see the docket now. Every time respondents with great respect.
With a different issue, my lord, then the
different issue, there is no doubt.
But yeah, I am not seeing it's that open access that is closed now. The industry.
Now 8
day, my lord, this
one submission
should be allotted to them.
One submission I made. From 8th respondent source, petitioner is running 8 megawatts capacity, which is AP Gas Power Corporation situated outside the state through interstate transmission. It is temporarily closed for the time being. Petitioners have permission to get it from the private operators through interstate transmission only. And they are denying this 8 megawatts power to the petitioner. Let them give clearance for 16.5. Events are not going to fall. Let that be an interim direction made with great respect to the other side.
Clarification regarding that.
You know, after filing counter, I don't know what started clarifying. You know, kindly pass an interim order, let him be ready whenever.
14.
Counter is fine.
ఎప్పుడు సార్
Well, 28.
May I pass on this? There is nothing in it. What the says, there is congestion in the. There is one document I will show you. Why? How they are lacking.
The power is diverted to some other purpose.
Yeah.
That's corridor is
Nothing. Simple.
Farmers.
It's simple thing is
the thing.
their power is more costlier. They want to coerce the petitioner to use their power. They want to deny this open access. Why? Because they want more. They want to supply power at a higher rate because they are losing money somewhere else because of free supplies and all. Then that is now only one document I will submit to establish my. The ninth respondent is statutory authority. There only one moment. No problem.
Please, sir.
Page 21.
Yes.
This is the statutory notification issued by the ninth respondent. A higher authority.
2023, April 20, February 2024.
They are high demand season, low demand season, kindly see. May to January 24. This is low demand season. If January is over, again they will say the low demand season over, we don't want to grant. Then that will be interim order till this January 2024.
Yes, sir. What is the third counsel for the petitioner as well as the students? At the request of the counsel for the respondent list on.
Who's there?
14th.
Finally,
final. It's final. Yes, sir.
For directed to produce the records.
Yes, production is tomorrow. We will grant you day after tomorrow. Please produce the records. It is a request of the EPC for production of records. This day after tomorrow. Yes, sir.
May it please.
Yes, sir.
Malad, item 80, Malad. In this Malad, I am appearing for the petitioner.
Sir, social welfare. I received instruction that transfer by instruction was completed before the government. Appeal pending.
Malad.
Appeal trial by petitioner master page number 33 participant. Yes, sir.
Let them serve that instructions on me, Malad. Lordship, I will kindly pass over the matter, Malad. I will collect the instructions, Malad.
Yes, sir. Tomorrow. Subject. List tomorrow.
Much.
Please.
Yes.
There's an incident not in both the matters because 81 and 8.
Yes, madam.
Seven might.
14. List on 14.
Till then,
Cannot be so and so, so and so. Intermodal extended for a period of 3 weeks. List on 14 days.
Yes.
Kindly see, they have to file the counter and vacate state. You ought to go please, I file a reply to this.
At the request of the council petition to file a list after 2 weeks. Intermodal granted so and so, extend 4 weeks.
Shorter extension, vacate your lordship. Then the lordship grant 2 weeks time, let the interim order be for the lordship.
Want, when reply 2 weeks. File it. Important to be there. File your 3 weeks extension. Extended 3 weeks, date even. Yes.
May I please?
Yes, sir.
The present expenses were against the official respondent without due process of law, they are directing the transfer of your lordship.
very disturbance to ingress and egress of the passage, Your Lordship.
21, sir.
As for the due process of law, they may be taken it, may be disposed of.
Note insisting produce of occupant certificate from both respondent. Who is both respondent? Yes, sir, TSHC, you want to file a NOC? Yes, sir. Electricity transfer actually power so and so. What is the extent of your construction?
Yes, Your Lordship, extension.
Construction.
Yes, Your Lordship.
Recently, how many houses you have constructed, sir?
5.
How many floors?
5 floors, Your Lordship.
166, 5 floors.
Yes, he has taken another premises before, Your Lordship. We are not concerned with the developer, Your Lordship. We are the owner of the said flat, Your Lordship. Before that, in entering into MOU, Your Lordship, he has, in the MOU, he has told that he will take permission from the electricity department.
How
But
can?
he has
without
not
offering
taken
any
permission.
certificate from the municipal authorities, how can he?
His admission before Lordship is to, with regard to the transform, Your Lordship.
My simple issues are, is an extent of 166 square yards.
Yes, sir. Another premises he has taken, Your Lordship.
How much that was?
That is also 200, Your Lordship.
260. How many apartment constructed?
Yes, sir.
How many floors?
G plus 4 floors.
How many flats?
Each floors 2 flats. 3.
Sir, what is it?
Next week, if I'm happy.
It's on 16th at the request of the council for respondent.
Maybe my simple submissions before, Your Lordship. Due process law may be followed, Your Lordship. And dispose of this.
You have to establish, if I, this is under Article 226, sir. Kindly note, it's not a post office. Simply file an application saying that I file representative before them without narrating any facts, without any NOC saying there, simply.
That's the reason.
List of signatures.
Motion list.
Motion list. Print the name of R. Vinod in the press of so and so, and print the name of JHM, Standing Council JHMC. Who is the Standing Council? JHMC, the party to the response. Who is that? Print the name of Standing Council for JHMC.
I filed vacate. Lord, 86, my lord, is filed challenging proceedings dated 14/8/2000.
86 and 87?
Yes.
87 and 88. Yes, sir. 87. Yes, sir. 87, there was an interim order. There are 2 matters.
Yes, my lord, 25949 of 2023.
Yes,
Lord, that is filed.
611.
Lord, in. Yes,
Yes, sir. Yes, sir.
Lord, in 242045, Lord, I am respondent. Lord, I filed vacate. Lord, the zone allocation made for 5 years. Lord, from 22-23 onwards. Lord, is challenged, Lord, in that writ petition. Lord, in that particular district, Lord, there are 2 Lord, sugar mills in operation. Lord, they have challenged that. Lord,
yes.
Lord, now there is an appeal remedy. They preferred appeal. Appeal has been dismissed. Against that, Lord, they have come in this present writ petition. Lord, in that writ petition, 2 IAs are filed. One is seeking suspension, Lord, of the zone allocation made in my favor with respect to, Lord, those contentious villages. Lord, and the other one is, Lord, they wanted to restore the position back to 2015. Lord, that is even prior to the earlier block period. And that, Lord, the Honorable Court directed them to consider that representation. Lord, while considering that representation without any notice to me, Lord, stated on recording any reason, saying that because of interim order, they have just like that, they have restored. Lord, virtually, Lord, now their prayer in the writ petition is ordered now. They have been now put back to 2014 position.
But these villages are under my Lord zone area. Not only the current 5 years, which commenced Lord from 22, but prior to that also, Lord from 2017-18 to 2021-22. Lord, therefore, Lord, the understanding was that Lord on last occasion, Lord, the matter was Lord fixed today for proceeding with Lord hearing vacate petition.
Your Lordship, Senior Counsel Mr. Sri Raghuram is engaged in this matter, Your Lordship. Some person inconvenience is not able to just requesting for it to be posted on Wednesday, Your Lordship. This Wednesday he is to appear.
Lord, I have asked only for today.
After tomorrow.
Yes, Your Lordship.
Again, you have to say. Ready, what?
Tomorrow.
Morning day after game on the request of the council for the petitions on the ground of the list on Wednesday. 8.
Very well.
What the matters?
Yes, sir.
Yes.
What is the role of advocate general in this matter? Assistant advocate general, yes.
First and second respondent, my lordship.
That they file counter, Lord, they are supporting Lord, the order passed by the commissioner.
For the petitioner, my lords.
It's a requested deep dive, my lords, in this matter, especially on its next week of first report, my lords. Status was being granted in this matter.
Yes, suspension has been granted, my lord. Your lordship may extend the interim order.
Dear model granted someone to election of. What do you want?
2 weeks.
The file will counter?
Yes, my lords.
No. Interim model granted someone so extend the. 2 weeks. Interim model granted. Up to 15th.
Yes.
Up to 20th of this month. List on 16th. Yes, sir. Yes, please for the petitions. If you're taking up next week. Then a bit for the petitions. Next, who is for the petitions? A bit for the petitions. Stop to do this. Yes, sir.
Counter file.
Who is for the petitions?
Lakshmi Kant.
Yes, sir.
I'm appearing for the petitioners, minutes.
Yes, sir.
Minutes, in this matter, the pleadings are completed. This is coming for the final arguments, minutes. If the other side is ready, minutes may take it up on 14th, minutes. The senior counsel is engaged in this matter, and 14th will commence the arguments.
The request of the council for the petitioners. List on 14 for arguments.
The pleadings are completed.
Yes, sir. Counter verify is lab is for the copy. Yes. Verify it. Counter. Yes, sir.
Counter is there, it's on the record.
Yes, sir.
Got the response for interviewing.
Deep
92 and 92 and 94 are the same.
Yes, sir.
Response immediate target for interviews. All last occasion we are we said the DP for revenue.
Yes, sir. DP for revenue. Assignment. Assignment. Item 92, is it?
92 and 94.
94 of the same. What is the name of DP for assignment?
Already last occasion.
DP for revenue. Assignment. For the petitions, you are? Yes, sir. Oh. Yes, sir. Okay.
Yeah, under.
They are saying that your Patadar passports have been already.
Old passport they are running, but they
Say that the paper revenue assignment. List tomorrow. Then the name of the also from the list tomorrow. Yes, sir. Both the matters. 92. మినిమం కనెక్ట్ అంటే వెరీ కదండి. Please inform to GP for assignment office. Yes, sir.
May I please, madam? The grievance of this writ petitioner before this honorable court, my lord, it was a industrial plot allotted in the year 2010 itself. This land was allotted to the third respondent through second respondent at a concessional rights. But after one long decade, the same property was alienated to some other party. Just by giving a legal notice, by notice, it was alienated in favor of some other third party. My humble submission before this honorable court, just before the COVID, the petitioner also filed Udyog Aadhar memorandum registered with Ministry of Micro and Small Medium Industries government before the government of India, and same was filed before the third respondent. But within a filing of this, within 35 days, hardly 35 days, just before the COVID, just by giving a legal notice, the same was cancelled and allotted in favor of some other third party. It is not a profit-oriented company.
It was allotted to you
Yes, ma'am.
in the year
2010 itself.
Okay. There was a condition that you have to complete the process.
Yes, ma'am.
5 years or 3 years, sir?
10 years.
10 years.
My lord?
Not 10 years.
Yes.
5 years.
In the year 2000, conditions 5.
There was a condition that you have to complete the construction of this particular unit and you have to start this process within a period of 5 years. So that is 2015.
Right.
Yes, sir.
And just in the year 2020, even before Udyog Aadhar memorandum registered and
What is your response?
Yes, my lord. Sir, at least my humble prayer before this honorable court, they alienated this. This is not a. It was the company registered under Section 25 of the Companies Act. It is not a profit-oriented company. They sold it at 92,92,400. But in the recent telephonic conversation, the third respondent said only that 15,11,000 and odd in which the amount which was paid in the 2010, they were prepared to refund that amount only. Here, my humble submission before this honorable court, at least honorable court may please to direct them to return the amount what they were sold, what for which amount it was sold. In the year 2003,
to pay the entire sale consideration to me.
Yes.
92 lakhs.
It was the
18%.
My lord?
Along with 18% of.
It was sold in the year 2021 itself. But in recent telephonic conversation, the third respondent said only that you take that 15 lakhs, 11,000 and odd. That was the amount paid in the year 2010 itself. At least the honorable court may be pleased to direct the entire full amount to be paid to them. Because this is not at all a profit motive company. It was registered under Section 25 of the Companies Act. How can they distribute what they did that amount, the entire 92,92,000 and odd, that 400 amount, my lord? My humble submission before this honorable court, that is the honorable court may be pleased to direct to refund that amount at least. Instead of that.
How much they deposited?
Third respondent, my lord, your lordship. COVE, my lord, Confederation of Women Entrepreneurs.
Confederation of Women Entrepreneurs.
Respondent allotted to this third respondent.
Yes, it at a concession rate, the second respondent allotted to the third respondent. Because the second respondent, third respondent allotted to the petition. What prevents them to pay at least that amount, my lord? That's what my humble submission.
They have to
This for the third respondent is.
COVE.
Confederation of Women.
Already, this honorable court directed me to give personal notice. I already filed the proof of service also. It was served against them.
None of years. For correct file. Oh, 11 only. Will this next week? We see.
Before vacation, notice order, my lord.
Notice order, I already filed proof of service.
Spite of this court directed, this petition comes for the petition to take out personal notice.
96. Item 96, Lakshmi kindly take it up.
96. So 96 for one.
What they matters, they go together. The petitioners are different legal entities. They are running two different tiny industrial, small scale industrial units. And there is an inspection, page 15, Lakshmi kindly see, the impugned notice.
Yes, sir.
They say there are the industries are being run in two different sheds. But what they state is that they are in the same shed. They are asking the petitioner to club both the loads because since it is above 75 horsepower, and all the statutory clearances kindly go to page 16.
Yes.
Registration certificate. This is in the name of the proprietary of the petitioner, Sardar Charanjit Singh, Chawla Industries. Kindly see the other page 19. This is the allotment of share by the Andhra Pradesh Small Scale Industrial Development Corporation Limited in favor of the petitioner, Chawla Metal Industries. Then page 20 onwards, these are the invoices raised by the petitioner unit during the course of its business. And IT returns are also being filed in the name of the proprietor of the petitioner insofar as this unit is concerned. Similarly, the other unit also, it is Bharat Ice Industry, and similar licenses are there in respect of that unit also. Then now what they are invoking is condition 3.5.3. They are skipping now, they're skipping this 3.5.1 and 3.5.2. But kindly read these provisions. OPC. Definition of separate establishment. For the purpose of GTCS, separate establishment shall include following types of establishment: having different setup and staff, owned or leased by different person, covered by different licenses or registrations under any law where such procedures are applicable. For domestic category, the households having a separate kitchen. Each separate 3.5.2 is important. Each separate establishment will be given a separate point of supply. What they want to invoke is 3.5.3. Notwithstanding the above provision, the company reserves the right where it is reasonably established that the consumer of the same group or family or firm or a company who are availing supply under different service connections situated within the single premises by splitting the units, the company may treat such multiple connections existing in the single premises as a single service connection and charge the total consumption of all the consumers at the appropriate charges applicable for a single service connection. Any officer authorized by the company shall issue notices to the concerned consumers asking them to furnish a single application for all such services and pay to pay required charges for merging the service connection into a single service. Wherever total connected load of all such multiple connections exceeds 75 horsepower, the consumers must be necessarily switch over to HD category or LT category 3B as the case may be and regularize their services duly following the procedure for availing such supply within 60 days from the date of service of such notice. If the consumer still fails to pay the necessary charges to convert to the specific category, the services will be disconnected after 60 days from the date of service of the notice. Pending such switchovers, the licensee shall be entitled to bill the service at the HD tariff as per the procedure mentioned under clause 12.3.32. Then kindly see petitioner case squarely falls under 3.51 and 3.52. They are covered by different licenses. Petitioner all through is being charged under LT category 3B. That is industrial category. Now what they want, you club both the service connections. That means you club both the businesses. It is impossible in law to let club the businesses of two separate proprietary concerns, statutory entities. But now they have issued notice, it was served, impugn notice was served on 23rd. 60 days time is there. In spite of it, within 1 month, they have disconnected the power supply. Now both the petitioners are under disconnection now, as of now.
Right. The lordship of this statement, notice. Page 15. Notice. Yes. Yes, well, at the last para, you have to approve. It is requested to submit updates in penny with necessary relevant documents to the office within 15 days from date of receipt of this notice. Otherwise, service will be clubbed to a single service and will build the ST category. Well, they did not submit any reply at all. The lordship has to.
Where is the objection? They have disconnected the power supply.
After 1.5 months.
Not that, I'll give the dates. That is the problem with the respondents is they don't come up with great respect. They don't come up with real facts. Kindly check the fact. 26th August 2023, impugn notice was served. On 29th September, they disconnected the power supply. 60 days time is not over. Moreover, on 2 grounds, I have filed this writ petition. One is statutory infractions are there. When petitioner case squarely falls under 3.51 and 5.2, not 3.53, because that is advantage, because they are different statutory entities covered by different licenses issued by various competent authorities.
The order passed by my Lord Justice Lalita Kumari will rise.
Apply.
The reading of your note itself, we show that you have given. The service connections are only in the name of Charanjit Singh. 2 service connections.
It can be. It can be. If I'm tenant, I can have. I can't have service connection in my name. It will be in the landlord's name.
Well, your lordship will take the count of the.
Yes. Second writ petition, please take up. First, it is.
Yes, sir.
First writ petition. I show the. Page 16.
Yes, sir. 287.
Yes. Then kindly see the page 19. Page 19. Page 19. This is the license. Page 19. First writ petition.
288. Yes.
28807.
Yes, sir. Page 19. Yes.
Yes.
Yes, sir.
Registration certificate. Legal name Sadbir Singh. Trade name Bharat Ice Industries. Then, Lakshmi kindly see page 23. There are the different invoices issued by the petitioner consent, sale bills. Then page 26. This is the allotment of shed by Andhra Pradesh Small Scale Industrial Development Corporation, that is shed number with reference to your request, the change of name of your so-and-so, Mr. to Bharat Ice Industry, taking Srimans Jagjit Kaur as a partner for running ice cube industry in shed number 56. Kindly see in the second case, shed number 44.
Senior, have you gone through the counter report filed by the respondent?
Yeah, what I have submitted, same thing.
Have you sent panel number 5 of their counter?
Yes. I filed the reply also to that.
Yes, sir. Yes, sir.
Me counter down. First the
reply. Yes, sir. Reply.
I go as per the counter.
Reply.
They are evidently they are being run in 2 different sheds. Assuming that they are in same premises.
Specific condition that you are utilizing the connection from others, which is situated in the same premises.
No. Yes. No, reply. There is no interconnection between the industries. What they state is that these firms belong to father and son. They are different legal entities. They are not disputing it. And there is no interconnection between these two units, that also they are not disputing it. Interconnection of electricity service connection or the plant and machinery, they are separate.
Where is your request? Counter the corruption. Tomorrow, reply, senior tomorrow.
Yes.
Yes.
Right.
Madam, every time you will be a name after name.
Yes,
Day after tomorrow, but Monday assignments. Yes, sir. Go to reply. Any doubts, I'll ask and find out. Day after tomorrow. I told him, Monday. Wednesday.
It was 97 constitution of the.
Well, I don't know, so that time. I don't know. What is also.
None appeal for the petitioners. LT category number 3. We have none appears for the petition list after 2 weeks. Any interim order? Yes, list next week. Yes. We are senior.
Make these rounds. The petitioner fell into some kind of greed, my lord, he was enticed. He belongs to SC Madhika community, he was enticed to convert himself into Christianity. And then, my lord, after he realized that it was not correct, he asked for this, he reconverted himself into Hinduism and asked for the cancellation of the my lord, the caste certificate issued to him pursuant to his conversion. He has filed an application, my lord, page 15.
Page 15.
Yes, my lord. That may be directly be disposed of, my lord. Whatever comes from it, they will accept. Page 15, my lord. Next is for cancellation of the BCC certificate pursuant to his conversion into Christianity. And it is permissible, my lord, under the page 51, my lords, my kindness.
Yes, sir.
My lords have seen page 51. 51. Yes, sir. Para 8. Cases of conversion and reconnection.
Yes, sir. Yes, sir.
Well, it clearly says that where a scheduled caste person gets converted into a religion other than that of Hinduism or Sikhism or Buddhism, then reconverts himself back to Hinduism or Sikhism or Buddhism, he will be deemed to have reverted to his original scheduled caste status.
Yes, GP, social welfare.
Possibly social welfare.
Yes, madam.
Representation disposal.
What is the name of GP for social welfare is tomorrow? Revenue name is there.
Infections connected.
Page number so. It's running. If TR code is around, we can have one. Had issue notice to the petitioner on notice it children, sir. Don't even only issue notice to the petition since the consumer petition is faster. Verify. Don't. Answer. Alright.
Same
1.5%.
Yes, sir.
My lordship, senior is held up in part-heard matter. My lordships, I'm appearing on behalf of
Senior is held up in.
part-heard matter in other court, my lords.
Respondent.
Respondent number 5, my lords.
You are for respondent number 5. Who is for the petition, sir?
Next week. Requesting for next week.
None appear for the petitions. Which chapter attending, sir?
Obliged.
Item 102.
Yes, sir.
Lord, in this, my lord, it's supposed, my lord, I think, my lord, it belongs to state of AP, my lord, all the other respondents, because the cancellation of, my lord, the caste certificate by the collector Kadapa.
Represented by the council for the petitions. Because of the recordation of the last jurisdiction of the Andhra Pradesh High Court is on the record.
Now, my lord, in view of that cancellation of the caste certificate, they want to terminate the services, my lord, that cancellation order has been suspended.
Both are connected.
Both are connected, my lord. And third one is also, my lord, my lord, in view of the interim order, because he has, he retired from the service and terminal benefits are all.
Nothing survive. మన పోదాలో పెట్టాలి కోర్టు ఒకటి ఇక్కడ ఒకటి అక్కడ చెప్పండి మీరేటు వెరిఫై విస్పర్ ఫర్ ఆర్డర్స్
Because, my lord, now, my lord, he is retired and terminal benefits are granted, my lord.
Where is Mr. Dr. Lakshmi Narasimha? We'll do one thing, 103 and 104, please tomorrow.
104, my lord, belong to, my lord, the petitioner in earlier matter, she is the daughter. She got a PG seat in medicine. And, my lord, now that completed the course.
Lakshmi Narasimha garu GP plus what will find out.
In fact,
then
my lord,
104 next week.
in fact, my lord, in third matter, Narasimha is not appearing because he is only appearing.
Yes, sir. 103 and 104. List on 15th will verify. చూడండి లోపల చూడండి చేద్దాం. Yes, sir.
Instead of 15th, my lord, because I am from 15th to that weekend, I am not available.
21st.
Okay.
For orders, yes.
But
Yes.
first matter, your lordship transferred to
Transfer to APC. Yes, sir.
Hello.
Want to disclose the evidence. Yes, sir. I'm not here for the petitions. For discussion. 14. Yes, sir. Yes, sir. I'm happy about the petition. Post on 14. Yes, sir.
My lord.
What about 107? Yes, sir. 107. Both are.
Your lordship, 108.
Yes, sir.
Lordship, 109.
108. 108 is.
Item number?
108.
109.
Yes, sir.
Sir, 3 weeks time may be granted. He is not instituted by the agreement of by the official liquidator. Their company was already in liquidation. They are the purchase.
Yes, sir. What is it?
Any date. Any date may be granted, my lord.
What is it?
Respondent counsel is here, my lord. He is seeking also time.
Written of entire city consultations of 12 lakhs.
So, we're ready for a.
2 weeks may be granted for ordinance.
ఎందుకండి 10 లక్షలు అడుగుతారు వాళ్ళు అడిగున్నారు ఏం కావాలి మీ డబ్బులు వద్దా రిక్వెస్ట్ ఆఫ్ ది కౌన్సిల్ ఫర్ ద పిటిషన్ లిస్ట్ ఆఫ్ క్యాండిడేట్స్ ఎందుకు
My apologies, my lords. Item number 108, my lords.
అదే కాబట్టి సార్ ఇంకోటి ఎటువంటి సార్
Obliged, my lords. Yeah.
Yes, sir. For the response. Central Power Distribution Company. Yes, sir. Who is standing as? Yes, Hira. It is no item in 110. It is spelling the name of R. Vinod Reddy. Counsel for the respondents. Nana bill for the petition, list after 2 weeks. Yes, sir. Yes.
I beg to represent Venkat Mayuri. This petition is challenging the action of respondents in issuing the memo to a impounding memo.
Yes, sir.
Was issued on 24th.
Yes, sir. Disconnection of.
Yes. Even though there is an interim order, they have collected.
Sir, you are for the respondents? Who is for the respondents? Central Power Distribution Company.
I'm there, my lord. The prayer, if your lordship may see, my lord, here, direction is, we are praying for direction to respond number
1 and 2.
Respond number 3. That is 3 and 4 we are up. That is a Gurukulam and special officer.
Second respondent, Kalyani is up there. Her name is not
What is
printed.
the name of so and so, so and so?
Kalyani.
Kalyani.
AGB.
But there is no stay, I think.
Well, their direction this is
Second respondent.
not to
Order
be
is there.
the service connection of the petitions. List on 16, sir. Yes.
Like.
There is a file by lord.
And none appear for the petitioners. None of petitioners, sir?
Dismissal.
Yes, sir. What is the name of R. Vinod Reddy? First. Monday, Tuesday. Yes, sir.
Item 113 and 114 is granted. Item 115 Balaji in Prabhakar Reddy.
Yes, sir.
This matter, this week's fair will not be not having the funding.
You are for the respondents? Yes, madam. Yes, madam. You are for the petitions?
Yes.
The
I am
request of
separating
the
the file.
petitions. List on 21st, please, sir.
Obliged.
Item 116 TB Kanna DP plus social welfare.
Yes, sir.
It is my question in the form may not lodge.
Yes.
Also not when the petitioner questioning that questioning the form G notice lodged rejection order. Rejection notice lodged.
Yes. The request of the constable, the respondent. Tribal welfare. Yes. List on 16th profiling counter. Sir, old matters.
Item 117 day monthly about 2%.
Really? The council.
Granted, each time, but we have to verify this.
I hear correspondence. Yes, sir. Put the name of Sri Jackie Rali Danish. Take the name of Manohar Reddy as well as P. Vinod Kumar. At the request of the council for the petition. List on 17. Yes.
Item 119, MS interest note from Prabhakar Reddy.
Yes, madam.
After 3 weeks. Bundle.
Old matters.
Bundle is it?
At the request of the council for the respondents.
Petitioner counsel.
Yes, IAC.
Yes, petitioner counsel.
List on 21st for bank account. File it old matters.
Item 117.
Yes. Any counter?
Counter is filed, they have also filed vacate petition,
Yes, RT3.
but Mr. Mayur Reddy name is printed, I think he is no more there. Counsel for RTC.
Depot Mirror Janagaon. Who is for the RTC?
RTC Warangal.
Yes, RTC Warangal. RTC Warangal. Put the name of says, Gadam Srinivas. Mostly for the respondent RTC. 21. Yes, sir, fine. Here matter is there. List on 22nd. For filing counter.
No, counter is already filed.
Inform.
Item 121.
Read the name of Manohar Reddy as well as P. Vinod Kumar. Jackie Rali Danish pair on Chatty.
Yes, sir. In your case of Millard, when late payment surcharge has been imposed, 50% has been paid. Now another 50% to be paid.
We'll see. One appeal for the petitions. List on 28. Yes. Yes, sir.
Item 122, 127, item 124.
Lordship, my grant only 5.
Yes, in purchase. In purchase?
Item 124, this are the requested material. Next week, no, I'll inform.
Purchase, is it? Run So I will come for the petition.
Chip, request 2 weeks time, your lordship, to get instructions from the client.
Yes, what did you say? Vinod Reddy garu. Yes, sir.
Handicap with the problem.
Lord, it is actually, Madam, to filed a counter. Extra has paid 50% of the amount, my lord. The other 50%.
Yes, 21.
Next
21 month.
2 weeks, your lordship, within.
Already there.
List on 16th at the request of the constable of it. Yes.
Already.
Item 126, parking ready. But sir, we are going to file the Wakalan conversion 2 weeks time.
Yes.
M. Kiran Reddy.
Kiran Reddy. Already there. What's the name of M. Kiran Reddy? List on 16.
I'm sorry. Item 127.
Should take on Yes, sir. Yes, sir. Yes, sir. LTR. Because of the council for the respondents. వికెట్ కూడా వేశారు చూసుకోండి. List on 15 చూసుకోండి వెరిఫై చేయండి. List on 15 తీసుకోండి. Yes sir.
Item 130 search, item 130 list of the
Yes sir. Print the name of Southern Power Distribution, SPDC. SPDCL. Right, print the name of those are on the video. Delete name of woman already. What do you want, sir?
We are ready to that.
Run again for the petitions. List on 20th. Yes, sir.
item 130 proper thing, home already.
APCPDCL. Yes, print the name of Sri Ram Vinod Reddy in the place of woman already. Run again for the petitions. List on 16th for discussion. Yes. Yes, sir.
Item 133, Kendriya Centra, 133 and 134 adjourned.
Yes, sir. Who is for the respondents?
I am appearing. Your lordship already directed in the morning.
Yes, print the name of so and so, so and so. Jackie Validans for the respondents. Yes, sir. The date to come my pictures. We know P. Vinod Kumar are very decent. R. Vinod are very good decent. Yes, sir.
Item 136,
My lords, requesting 1 week's time, representing the petitioner. Seek instructions, my lords.
On 10th February, at the request of the constable of the petitioner, G. Aravind, yourself?
No. My obliged.
So what do you say? Double will be also dispensed. When do you want? When do you want?
1 week takes enough, my lords.
Yes.
Ratings are completed matter for the section. You file founder and they try to play up the back.
Another for the petitions. First.
Telangana, AP debate.
138 days to be needed restricting of.
But I am online, my lord. Lordship
Yes.
can hear. My lord, my video is not working. Kindly pardon me for that. Some teething problems will have. This is a matter which your lordship can recall, my lord. If your lordship just sees the docket, I have argued everything, my lord. I have submitted written arguments also.
Yes, sir.
So I have nothing to say in that, my lord, other than seeking your lordship's indulgence to go through the.
I'm representing J. Sudhir.
Okay.
Lord, we have to put an end to this, Lord, because your lordship can appreciate, Lord.
Yes, sir. Yes, sir.
This is 2000.
Yes, sir.
That's all. I have nothing to say, my lord, because your lordships were
I'm
patient.
not for the respondents. It's on 14. We'll see on 14, sir. We'll see.
He's, my lord, if they are
Under
not even,
same caption. Sir, under same caption, no problem.
no, they are not even coming, my lord. This is very unfortunate because.
So that's why. We'll see on 14. Yes, sir. Yes, sir.
Oh, bless.
Please, Sudhakar. List on 14 non-appears.
Very simple matter, my lords. The alarm of the petition before the court, the refusal they filed has been dismissed and the order has become final. In the counter, they say I'm eligible for 2 increments. I'm asking for 3 increments. Lordship may observe that, let them give that 2 increments, my lords, and close the case. Because in the counter, they say after the reinstatement, the previous one punishment is there. Hence, we are delaying your increment of 1 year.
2 increments.
2 increments.
While small affidavit, when the request of the council of the petitions confined to the extent of.
No,
granting-
Lordship, the client is not coming, hence I'm telling this. Like, I would have filed a reply for 3 increments itself. Lordship pass some order. I'm being.
Yeah, accepted 2 increments.
Yes.
Lordship, I am representing Hanumantra, Lordship. Petitioner's side arguments is over, Lordship. Kindly please allow the petition, Lordship. They are not coming at any time, Lordship.
Who is for? Respondents, huh?
I am for the petitioner, Lordship, Hanumantra.
Yes, ma'am.
Kindly allow the petition, Lordship.
You are Shravani?
Yes, Lordship.
You are saying that pleadings are over.
Yes, Lordship.
Promise, huh?
Yes, Lordship.
వద్దాం కాదుగా?
My seniors said
అలా
that.
చెప్పారా? 26/4/2022 the request of the council to the petitioners. 17/10/2022 before my lords Justice E.B. Venugopal at the request of the council for the petitioner. Shravani represented on behalf of the B. Hanumantra saying that so. Again, listed some other bench. 23/1/2023 at the request of the council. Southern Power.
Yes, Mr. Vinod Reddy.
Vinod Reddy. Again, that TSS PDCN.
Same. Short form of
What is the name of R. Vinod Reddy? List on 16 yes, at the request of the council for the petitions too. Yes.
Much obliged.
Yes, yes, ma'am.
Development of the item 5 and 6.
Yes, sir. All issues raised in the present petitions have already been answered in the earlier round of litigation, and this court concurs with the చెప్పినా కదా బాగా అతనికి నో నీడ్ టు వరీ. ఎప్పుడు కాదు మేము మోషన్ ఇస్ కానివ్వండి. మోషన్ ఇస్ చేస్తా చెప్పాను ఆర్టీసీ స్టాండింగ్
Yes, sir. Item 18, filling up the rubbing executor industries.
Your Lord, I am sorry, my lord, should have been physically present.
Yes, sir.
I am appearing in item 18, my lord.
Yes, sir.
The respondent had, my lord, allotted a plot. My lord should get the allotment order, my lord.
Yes, sir.
In the year 2020, my lord. That's at page, a project letter, page 18, my lord should see.
Yes, sir.
14/12/2020.
Yes, sir.
Thereafter, my lord, after payments of the amounts, my lord, which I am required to pay, my lord, at page 16, my lord should see, 22/5/2021. My lord, we say that I have paid the entire amount. This is the confirmation letter, my lord. I'll read. In continuation to the reference cited, it's to inform that the allotment of plot number 17, survey number 5/1, measuring 4047 square meters at Industrial Park, Rakamachalla, is hereby confirmed in your favor as you have paid the total sale consideration of land amount to 40,47,000. Then, my lords, there are two terms and conditions. The sale agreement is taking physical possession. Sale agreement was also executed. My lords would get the sale agreement at page 31, my lord should see, 13/7/2021, page 31, my lord.
Yes, sir.
Then, my lord, because there was certain, my lord, problems with regard to the access to the plot, my lord, immediately we could not commence the project. Then, my lord, we requested the respondent, my lord should see, my lord, the letter dated requesting for extension of 2 years time. My lord, wide our letter dated 18/7/2023 at page 15, page 15, my lord.
Yes, sir.
Lord, we have requested for, we have narrated, my lord, the reasons as to why we could not commence the project and requested for 2 years time. Lord, this was accepted by them. Lord, that's at page 14. They have extended the time. Lord, the time has been extended up to 12/7/2025. 2 years time has been granted. Page 14, my lord should see.
Yes, sir.
But, my lord, the issue is, when my lord, they're asking me to pay 3% of the present land cost. My lord, my lord should see, my lord, at page 14. You should pay process fee 3% of the present land cost, which works out to be 6,94,591 and 1,25,000 toward GST. Totally. My lord, I am agreed by the 6,94,500, 3%. In fact, the regulations contemplate. Suppose I request for extension of time prior to cancellation. It's only 2% for 2 years. My lord. Immediately I make a representation. So that's at page 12 in response to this 3%.
3% has to be in the
Page 12.
abundant regulation,
Yes, sir.
allotment regulations.
My page 12, my lord. Page 12, I have quoted, my lord, regulation 23.2. And my lords have got the regulation in your hand, my lord.
Yes, sir.
Page 12, my lord, so I have, my lord, quoted the regulation. And I said I'm entitled to pay only 2%, not 3%. Because 1% per year is charged. Because this is an extension which I am seeking before cancellation, my lord. It is not after cancellation. My lord, this was rejected by the impugned order. Now, my lord should see.
Yes, sir. Yes, sir. Yes, sir. Bill 11.
A reading of 23.2, my lord, clearly shows.
Yes, please.
My lord should see. 23.2, penalty, my lord, the title itself is penalties. Then my lord should say where allotments are it starts with where the allotments are cancelled for non-implementation of the project within 2 years. Then the last one, my lord should see 23. But if a request is made for extension of time for implementation of the project before cancellation, my lord got it, my lord.
Yes, sir.
Regulation. Before cancellation of the allotment, a fee of 1% of prevailing land cost may be levied for every year of extension. So therefore, 2 years I have sought 2%.
Yes.
This is regulation 23, my lord.
Yes, madam. What is it?
Amended regulations, 3% has to be in the for 3 years, not 2 years extension, but 3 years. As per amended data. 3% has to be part sub. Paper mill identification.
Shall we share these proceedings to the council of the petitioners? This proceeding?
No.
Please share it.
Scan.
Yes, sir.
Regulations, my lord. These are the regulations. I don't know the proceedings if they have issued. They would not.
Now the council for the respondent corporation submitted one proceeding, sir. Kindly go through it. I will have it tomorrow.
Very well, my lord. I'll go through it.
Please share it.
My colleague is there, my lord. She'll take a call.
Very well. Just tomorrow. Yes, sir.
Item 20, and Shivakumar GP petition.
Yes, sir.
This is the Malekwander. Order passed in 28/6/22.
Where is that?
Being Mallet, trial Mallet. The month of June,
Aye, what?
21 Mallet.
Aye.
Yes.
Yes, sir.
Despite the order Mallet, they are in
second. Yes, sir. What is it?
This matter, Malad, is seeking for being mentioned, Malad, IA 1 of 22, that may be ordered in a stipulated period.
Why stipulated period?
Another matter, Malad, we issued a letter, Malad, unable to get any instructions from the respondents.
28th day of June 2022.
22.
Corona period. Hang on, my respondents.
After that, Malad, petitioner council not filed within a 1 year period, Malad, they not called.
In the light of the judgment and another coordinate bench of this man on report explanation of the recognition is disposed, I will respond to instruction to consent to release the aided salary petition effect from 1/4/1992, from which he was absorbed so. Then ఎందుకు implement చేయలేదు?
The reason, get instruction.
ఏం instructions?
Not compliant.
అది ఎందుకు దేని?
Never to get instructions.
Who has to implement it?
First respondent.
District Education Officer.
In fact, Mallet, the earlier school.
Sir, in fact, sir, ever implement చేయాలి first of all. Who has to implement this order?
Fifth respondent, Mallet, in fact, Mallet, the special officer with the executive education service.
What is it?
There is a direction to the first respondent, Malad, to issue necessary instruction to the concerned release. That is the TU Karimnagar.
Okay. Randy. This reprimand has been filed. Order of 1%. Yes, sir.
Evict appearance. And,
Yes,
this is a repetition. Yes, sir.
Yes, sir.
Millard, questioning the Millard, the tender notification, Millard, inviting tenders for the disposal of Millard pond ash. Millard, by fixing the Millard, the rupees 150 per metric ton. Doubling the Millard, the last year it was only 75. That was the highest bid amount quoted.
Yes, sir.
And the reason Millard is Millard that the heavy storage of Millard, the pond ash and fly ash, Millard causing pollution, water pollution, air pollution, and Millard, the people are affected with this. They are suffering with the chronic diseases, and even the cows and buffaloes, Millard, dying Millard due to the polluted water. That in the area it is Millard widely published in all the newspapers. Now, Millard, this time the tender notification was issued. Millard, at page 22, Millard is 19 is the Millard tender notice.
Yes, sir.
This Millard, you Lordship may kindly look at Millard, para 16, the name of the product for sale, item 4, Millard, pond ash from so and so. Sixth stage. Then Millard, the bid validity, Millard, 180 days from the date of opening the price bid. This is Lordship. The opening is Millard on 26/4/2023 at 3 p.m.
Yes, sir.
Millard, at page 22, the scope of work, Millard.
Yes, sir.
The works, Millard, noted above columns, Millard, that in 3 stages of KTPS, Millard, 5th, 6th, and 7th stages, the pond ash and fly ash, Millard, is stored. And the minimum reserve price, Millard, the item 3 is scope of work, and is 150 rupees per metric ton for both general and reserve category, excluding taxes, so on so on. The duration, Millard, is from so on so 25/2023 from so. The bidder should quote Millard that, and the penalty in 6 Millard as a plus 6 Millard penalty clause is there, Millard 10% they have to. And now, Millard, though this note question, the Millard, issuance of this Millard, the petitioners filed Millard the respective petition. Millard questioning the Millard very notification is due to the increase in the price, Millard, the lifting of ash, Millard, is slowed down, decreased very much in the last few years. Millard, though the units were established in 98, 2011 and 2017, the commencement, the disposal is commenced only during the Millard 2017 and 18.
Yes, sir.
There are heavy Millard ash ponds, Millard, storage is more heavy. Millard, that I can get your Lordship, Millard, that
Yes, sir. Para number 14 of your affidavit.
that is there, Millard. So far as Millard, the application, Millard, the reply notice issued by them, Millard, for the RTA page 39. Yes. They themselves admitted that, Millard. Point number 4, 5th stage is established in 1997, unit is established in 98, and KTPS. 6th stage is Millard October 2011.
Yes, sir.
And Millard, then Millard, the disposal, Millard, from ash ponds is started in the year 2017-18. And then, Millard, I draw your Lordship's attention, Millard, page 40, and they cannot predict how much time it will take for disposal of this. And now, along with reply, we filed, Millard, the reply for RTA application. The corporation itself has given Millard reply affidavit is there. Page 7 along with reply affidavit.
Yes, sir. What do you say in response to the project
Millard,
officer?
there are, insofar as Millard, there are 3 crores 47 lakhs metric tons of Millard ash is Millard now stock is there, and Millard there are no bidders who come forward, Millard, in pursuance of during the pendency of writ petition. they opened the bids and only one person quoted 304 rupees 99 paisa per metric ton. That was the highest amount. Now, Millard, the other bidders, Millard, they quoted less than 200. Now, Millard, the corporation insisting on them to Millard match with the Millard highest price. They will only issue Millard if whoever comes forward for executing the work at the rate of 304 rupees 99 paisa. That is huge amount and not viable, and no contractor is coming forward. Though Millard, the tenders were opened in month of April, but so far no agreement has been executed and nobody is coming forward. And in the tender notice itself, the targets were Millard notified. Millard, sorry for the. Yes, sir. Let Millard page 30 along with the writ petition, Millard. These are the reaches, Millard, 5th stage, 6th stage, part A, item A. Yes. That Millard, every day the contractor must lift Millard 1150 metric tons. This is the target notified. And in the 7th stage, Millard, 430. Now, Millard, the counter filed by the corporation clearly shows that, Millard, you will actually counter affidavit at page 13. Yes, sir. Along with the affidavit, only one person is quoted in respect of Millard's 5th and 6th stages, where more than 350 crores Millard metric tons are storage there. Only one person, that to 100 metric tons every day. Against Millard, 1150 metric tons. And though these names are mentioned, nobody has entered into an agreement. The validity period is now over. Elapsed, Millard. When 180 days is Millard elapsed. As per the notification itself, as your lordship notice, the validity of Millard, the bid is only for 180 days. 26/4/2023, the Millard bid was opened. Nobody has come forward, and no Millard, there is no justification, Millard. And on the other hand, the government of India, one submission, Millard, government of India issued notification. It is the obligatory and Millard to the thermal power. Yes, 24. Yes, Millard. They must dispose of the Millard, the fly ash or pond ash immediately, and otherwise they have to pay penalties. Pollution Control Board has imposed Millard 6 crores or something in the recent period against this same corporation.
Fine.
Fine. And
so let us confirm to the extent of that there was a recommendation by the ITDA project officer to provide and give an opportunity to those.
Yes,
because you are filing an affidavit saying that they do not have any own vehicles. Unless they don't have any own vehicles, they can't.
They did not participate in the tender process, first of all. They have no locus to file the petition. First and foremost thing. And moreover, I have submitted on 30/9/2023. I submitted that out of 11 persons are already ready to lift the pond ash at the rate of 304.99 rupees per 100 meter per metric tons.
And last year metric tons against 1150. That is only single pitch. There are 6 reaches.
5th and 6th for 7 persons are there. And for the 6th, 2 persons are there. And for 7, 2 persons are there. 2 contractors are there.
Work to the petitions also.
They have not participated in the may submit a judgment passed by the Honorable Court. May.
ITDA has issued letters.
I have submitted that.
Earlier, all tribal agencies, they were used to give permission.
That was
allotment of sales were there.
It was there.
And during that kind of disposal was heavy. And now it is reduced. And with the 75 rupees, the contractors could not lift the as targets fixed by the corporation. Now 304 rupees 99 paisa means that nobody is coming forward.
They came forward
And if, no, Milord, my only straight question to the Milord, my respondent, Milord, that if the tenders are opened, Milord, in the month of April, 26 April 2023.
Yes, sir.
Milord, so far, no contractor has entered into an agreement with the corporation. Even after, Milord, the 6 months time is over. Milord, that itself shows that, Milord, no contractor is willing to lift the ash at the rate of, Milord, the 304 rupees 99 paisa.
Yes, sir.
Admittedly, more than 3.5 crores in one reach, Milord, the storage is there. And corporation is very much interested in spending the amounts, 28 crores, Milord, sanctioned recently, for digging, Milord, ponds for storage. Milord, no corporation is least bothered about the, Milord, the tribal people in the Milord and that area, where they lost their houses, their lands for establishment of these units. The Lordships aware, Milord, the ITDA and even collector also issued, and the provide, Milord, the work to the, Milord, the tribal people at that area. They are only, Milord, showing interest in the money, Milord, instead of, Milord, disposal of fly ash, Milord, to protect the lives of the, Milord, people at that area. The poor tribes are, Milord, suffering a lot. The purpose of very tender notification is now, Milord, lost its, Milord, sanctity, and, Milord, let them go with, Milord, fresh tenders and, Milord.
Yes, sir. What is it?
And in the counter, Milord, they did not, Milord, those documents were filed, the proceedings issued by ITDA, recommendation letters, and there is no reply in respect of them.
That's me. Prosecution Lordship directed file additional counter, Milord. And moreover, Milord, now, just my only, Honorable Court was petition 1263 of 2022. Already passed, Milord, judgment.
In respect of Vadra society is concerned.
No, same thing, same this area.
Yeah, that is in respect of Vadra community saying that they have not participated.
In the list of scheduled drivers, in this of it, you know, here it is in this judgment, Milord, the pair number 6 of the judgment.
It's not the question of participating tenders, Milord, that. Milord, our interest is, Milord, that the pond ash, fly ash, Milord, must be disposed from that area immediately. Quick disposal is not there. Due to the, Milord, increasing in the price, Milord, the lifting of ash is, Milord, decreasing every year.
Yes, sir.
Paragraph 6 of the judgment.
Yes.
Having regard to the fact that the petitioner have not participated in the tender process, even though 2 points have already been reserved for SC, STs, Vadra society like that of the petitioner, and that there is more quantity of fly ash and pond ash than that can be lifted, and also taking into consideration the fact that in the tender called for by the official respondent, the highest bidder is quoted 75%, 75 per metric ton. This court does not find any reason to entertain the present petition. The petitioners have not found any document to substantiate their claim that the official respondents have violated any of the guidelines of GO issued by.
Kindly read earlier paragraphs, sir. Admittedly, in this case.
Yes, sir.
Yes, page number 5 earlier.
Page number 5. Admittedly, in this case, the petitioners have not participated.
No, sir. You are reading page number 6.
Page number 5.
Page number 5 is the second paragraph.
Second paragraph. In the record. Admittedly, in this case, petitioners have not participated.
Yes, kindly go through next.
Moreover, as seen from the records, 2 points are exclusively reserved for SC, ST, Vadra societies, but even for that also, the petitioners have not participated.
Yes.
As rightly contended by the official respondent, the quantity of pond ash is more than that is lifted. Moreover, the petitioners have not denied that they have not lifted the entire previous
please come to the
quantity in the month of January, February, and March. As seen from the table, which has been mentioned in the paragraph 5 of the counter affidavit filed along with the vacancy petition, the petitioners have not lifted the entire allotted stock, and the said table reveals that the petitioners have orderly lifted only 10% of the stock allotted to them for the month of January, February, and March. Therefore, the contents of the petition that the official respondents are only with the view of the denial their employment opportunity or to see that the petitions are eliminated from the participating in the tender process have come with the said tender process appears to be correct, incorrect, and far away from the truth.
And the entire, my friend is trying to misread the entire, not this judgment, the repetition scope of the petitioner's relief is that they are asking their residents of that area, their people, their family members and others are affecting with the pollution, air pollution and water pollution. And for that they are asking quick disposal of ash by fixing reasonable price, lesser price, even giving permissions to the tribal agencies to lift the ash. In Vijayawada Thermal Power Station, your lordships aware, there free of cost they are selling the pond ash. And they are also providing machinery for loading the vehicles. Here, they are only concentrating on the money instead of their obligation to dispose of the ash.
Yes, sir.
The judgment is no way related to this case.
My counter category states
and may pass on the reply of David
paragraph 7 of my counter.
Yes, sir.
I submitted in reply to paragraph 5 of the affidavit, it is not true that surrounding villages are getting polluted because of non-disposal of fly ash, KTPS 5, 6 and 7 stages or till 1970. Since inception of the KTPS, the corporation is taking utmost interest in controlling the pollution level and to maintain the normal levels as prescribed by the TSPCB and MOEF and the CC of Government of India. Pollution control equipment such as high efficiency electric start precipitators were installed by TSGENCO and KTPS 5th and 6th and stages and all 72 fields always are in service establishing maximum ash collection at ESPs and from which as ash collection is discharged to soils in dry mode and disposed to the end users like cement manufacturing companies, bricks manufacturers, units and other users. Further, 275 meters high chimney is constructed in KTPS 6th stage and 7th stage and 210 meters high chimney is constructed in KTPS 5th stage as prescribed MOEF and CC Government of India as to be dispose the 5 ash particles in the wide area such that the ash particles concentration is within the acceptable limit at ground level. Further also, effluent treatment plant and sedimentation tanks are provided in both the plants in KTPS 5th and 6th and 7th stages to treat plant effluences and reuse of the retreat water in green belt development. Floor ash and other uses in plant use itself as such KTPS 5th, 6th stages are taken every care in maintaining pollution level in surrounding area of the plant. Though sea pond about 150 acres is abandoned, however, it is completely covered with trees like Milletria pinnata, that is Kanga Chetlu, and has been maintained greenery. Most of the area AB pond and additional ash ponds are also covered with grass to avoid air pollution. These remaining areas also keeping in wet condition with surplus water and with water tankers. The decanted water of ash ponds of KTPS 6 and 7 are very clear and every month of samples are being collected concern pollution control board funds within the limits and the same is being utilized for the fields of surrounding villages. My learned is my learned senior said that it will make polluted, but this is the fact. Just only oral allegations are being alleged by the learned senior council, but this is the fact on both on writing counter stating mirror. The northern ash pond 1, northern ash pond 2, the area of 183 acres and 246 acres respectively under control of KTPS 7th state are being maintained such that there should be not be any pollution nearby villages. Further, North Ash Pond 1 as efficient water sprinklers is also being carried out in Northern Ash Pond 1 and the Northern Ash Pond 2 is not in service and the entire area is consolidated and covered with grass. Further, NGT National Tribunal New Delhi has not imposed any penalty in KTPS 5th, 6 stages and 7 stages Palvancha as on date towards non-pollution, non-complying of the ash utilization. Moreover, the Ministry of Environmental Forest and Climate Changes, Government of India has published draft notification number GSR 285E dated 22nd April 2021 and invited objections or suggestions from any person in respect of the draft notification within the specified period for taking into consideration by the government, and hence contention of the petition is not true, baseless. Submit that the reply to the para 6 of the affidavit, it is not possible to dispose the pond ash free of cost. Since the corporation is gaining financially with it, the lifting ponds from KTPS complex is increasing year by year as there is increase in pond ash demand in the market and more awareness of utilization of pond ash. Following tabular form clearly states the area, the range of the increase of pond ash, utilization of pond ash, lifting quantity also increasing. From the above, it is evident that the contention of the petitioner in stating to increasing price with decreasing of ash utilization is not correct.
Yes, sir.
In reply 7 of the paragraph agreement, corporation has no intention to avoid local agencies or peoples to participate in tendering of pond ash and keeping view of the local and SC/ST Vadra society. One exclusive point is in each stage is reserved for them. Further, it is to state that machinery is mandatory for loading of ash into the truck. Without own or leased vehicles, it is not possible to load pond ash. However, some relaxation in tender specification made that those don't have own vehicle, they can also.
Also, any reference about the SC/ST people in Sober, are considered your tender application? Any reference or?
Yes, one point is no. But my
Kindly show me from your notification saying that you have given some importance to the local tribal people.
No, Mirad, for both, the price is fixed, Mirad, for general category and reserve category.
Show me that.
Yes,
At page 22.
Scope of the work.
Yes, sir. Page 22.
Scope of the work.
Yes, sir. This one, page 22, sir.
Yes, Mr.
Yes.
Mirad, item 1 itself, Mirad, minimum reserve price of pond ash is ₹150 per metric ton for both general and reserve category, including tax rate on it. And my only respectful submission to lordships, Mirad, the counter affidavit, Mirad, at page.
Yes, sir.
Page 7. Mirad, the tabulation, Mirad.
Yes, sir.
Tabulation. Mirad, during the year 2021, Mirad, 1,71,000. Unquote, 1,71,767 metric tons. 21-22, 3,11,576 tons. 22-23, 4,00,000. Mirad, just now I passed on, Mirad. Only in fifth and sixth stage, Mirad, there is 3 crores 47 lakhs to Mirad, pond ash in Mirad existing there. Apart from the 7th stage, that is more. That is also more than this. And now this is the status, Mirad, admittedly. And how many years they will take, Mirad, for disposal of this? And so far as, Mirad, the notification, you watch me, Government of India notification.
Yes, sir.
Along with the writ petition, I filed, Mirad, that at page.
Yes, sir.
Page 47, 47, Mirad.
Yes, sir.
The draft notification, Mirad, is a responsibility. Then the 48, Mirad, tabulation is given. How much percentage they have to lift the Mirad, clear the Mirad pond ash. Mirad, 80% within 3 years, Mirad, from compliance. And 60 to 80% 4 years and 60% 5 years. And here, Mirad, even after Mirad 20 years, they could not Mirad comply this one. And the penalty clause at Mirad, page 50.
Yes, sir.
See, Mirad, middle.
Fines for non-compliance.
Yes, Mirad. Just in the first 2 years of 3-year circle, if the coal and lignite based thermal power plant, including captive and so, has not achieved at least 80% of ash, fly ash and bottom ash utilization, then such a non-compliant TTPs shall be imposed with a fine of ₹1,000 per metric. And basing on this, the Pollution Control Board has imposed more than 6 crores.
They are denying that.
But of course, the proceedings is not there, but it is reflected in the papers and
Let them show before the honorable, let them probably the same thing before the honorable court.
And because in the counter itself, they admitted that last 3 years, last 3 years, they are not lifted more than 8 lakhs. When the in crores of metric tons are existing there.
Not even a single pollution control board given a complaint that we have violated the pollution control board rules and norms. And even National Green Tribunal also did not impose any single fine against us, as alleged by the honorable.
Promotes is the pathetic situation of Kinnarasani River. 1% of water, 9% or 90% of ash. Moving painfully, slowly like a sloth.
Last week, rather than me, because
how many metric tons are lying there?
I will furnish details. That's why I have taken time for
furnish phase 7 of along with reply.
I furnish details.
Just now I passed on.
Yes, sir.
Along with reply, the information furnished by the corporation itself.
Yes, sir.
Corporation. Reply.
Yes, sir.
Phase 7. Point number 1 itself. The legacy as stored in AB ash funds is about 3.47.
Yes, sir.
This minute, I have to get out. That's all. I have to get in last occasion, directed to file.
Find out some solution because
yes,
local drivers.
Local drivers, I am not denying about that. They are also employment also granted to them.
Bhumul is going to free game include Bhumul is going to charge.
Bhumul is going to charge all employment. That was by my
standing was 3.47 crore of metric tons.
Exactly, that's what I wanted to get instructions. Last occasion, last directed to file an additional counter. Like because of my
solution.
Yes, sir. Whether it is April 2022, 6th April 22.
Now, go to the committed in the counter, they could not lift more than in the 3 years, last 3 years. 7.5 crores, 7.5 lakhs.
It is social obligation and responsibility towards the nature, sir.
Basically, towards that,
find out some solution.
Yes, last
this day after tomorrow.
Let them participate in that. They did not participate in
any special category. Kindly show me from your notification saying
there is no
special category.
2% of works have been allotted to the local tribal people.
That's all. In my counter category stated that we have already employment furnished them and
this is in respect to removal of ash.
Yes, sir. Removal of ash. They are setting up since there is
about the recommendation.
Last year, see the count. Prayer start by the petition.
What do you say about the recommendations made by the ITDA project officer? Not only 1 time, 3 times, sir, 4 times. What do you respond? Your counter is silent about that.
The prayer will be seen. I am confined to the prayer.
Technicalities, sir. There was a recommendation by the ITDA project officer saying that implement GOM number so and so.
Yes,
97.
Yes.
What is your response?
Yes,
to
that was informed the honorable through my counter. My counter category.
Show me that.
Yes, sir.
Government.
Yes, sir. Right. That's right. Let's know what we do.
Para number 9.
Yes, sir. Yes, sir. I submitted the reply to the 7 of the corporation has no intention to avoid so. And further, it is stated that without our own or lease vehicle, and middle of the TSHC has given equal right opportunity to all agencies Hence, the sale of bond is not any work and it involves heavy machinery for lifting lorries, trucks and for transportation. Further, as per CEA Ministry of Power Guidelines in 17/7/2019, scale of fly ash should done by thermal power plant initially for end users industry. It is pertinent to mention here in that as per GOMS 97, 30 and 90 issued by the government, labor-oriented works such as jungle cutting, painting, earthworks, etc., which is mainly labor skills are being served for the SCSTs agencies. As submitted in reply to 8, in order to maintain transparency and to restrict malpractice, competitive bidding process is the most suitable method to determine.
Are you sure that 13 members have been participated and 10 members have given willingness?
Yes.
Are you sure that they have one vehicles to lift this sand?
Yes, sir. I will furnish the details of the everything. I will furnish. That's why I have got the time for counter.
Last occasion,
237 metric tons, crores of metric tons.
Yes. And very last occasion, are participated.
The sale orders issued to the millet, some of the contractors, they are not agreed, but the corporation itself is passed on last occasion. It's a, for every contract is 100 metric tons, as against millet 1150 metric tons.
Yes, sir.
This is the state.
This is there. That's why millet last occasion, court was based to file counter.
Every time millet, every
as alleged by the legal council, and we wanted to put it on paper.
No, they cannot pass on millet as
is to remove the ash ponds.
Yes, sir, we are doing millet.
ఎప్పటికో 237 కోట్ల మెట్రిక్ టన్స్ ఎప్పటికి
That's what millet. I will furnish details millet. What about the millet is there? What about the millet is there and how much it will be?
We want to remove this.
Let me give some chance millets to establish that what about the fly ash lying over there and how much it will be removed by stage wise.
మొత్తం బూడిదే పారుతుంది.
Admittedly, 50 tender millet tenders participated, contractors. Millet only few millet they come forward with legal because they will be blacklisted. Therefore, they were compelled to give the millet the consent for this. No agreement is entered into so far, and the validity period is over now. And the very notification itself now has no millet.
Are you willing to work? Rates millet by the others.
There are millet work is continuing. With last year, there are about 13 or 14 members. Contractors they are executing the work at the rate of millet, though it was allotted at 75. With enhanced rate of 100, they are continuing it.
Because
and due to this millet, now that will be millet. Though they may not execute the work, and here the new contractors will not execute the millet. That is the fate of the millet, this situation. Millet does.
Because the raise of the demand, millet they have the tender themselves are quoted for that. We did not demand.
మనం చెప్పే ఆర్గ్యుమెంట్ మనకి 234 ఎకరాల్లో రోజు నీళ్లు దొరుకుకుంటూ కానుక చెట్లు పెంచుకోవాల కర్మ ఎందుకు ఎవరికొనైతే మొత్తం క్లియర్ చేస్తారు కదా.
క్లియర్ చేస్తారు. What is your right to utilize that? 11 people are ready to participate because of the land, because of rain season. This 3 months we could not. Because of the rain season. Rain season we will.
No agreement is entered. Last 2 occasions he is saying millet.
That's what we
not a single agreement.
We want to search the way to clear the ash ponds.
That's what we learned. I'm given a chance. Millet. Yeah, I'm given a chance that how much quantity is lying there, how much it will be cleared within how much what time it will be taken by these level people. Just let me give an explanation.
List on Monday.
Meanwhile, not to give effect to the millet,
list on 14.
Millet, there may be direction millet, because next time you will come and millet say 3 or 4 people entered into
that direction is given.
That will millet prevent millet the old contractors from executing the work. Again, the work will be stopped.
No millet.
Nothing will happen if the millet into that.
Not to ask them not to enter to finalize the contract.
No millet. If that is the case, millet, it will become futile.
What is?
And they won't come forward setting a document and fly ash also will be increased. The ash will be increased, pollution will be increased as alleged by
It's a strange argument by my land friend. Now the problem is
now from now on,
who can live. That is not there. Admittedly,
for the month of saying they are going to live.
This is the
Already
sheet
last time told him, I was informed that it is already started, lifting is started.
No. Old contractors are executing the work. This is not a single agreement. My land friend is orally saying that. Now that's what last two occasions, Justice Nanda Garu insisted. Any agreement is entered. But so far, no agreement.
The agreement entered by you?
Yes, that's what we are. On 30th 9/2023.
These are the state orders issued by them.
State orders are issued. We have passed on a instruction. Copy is there already. 30th 9/2023. On the date the expedition was reaching. On the day it was instructed that 11% of additional sale orders issued in lifting pond ash on this day. The table of contents. And next second paragraph, next to the page, next page, more leaf. In addition to the above, requests were received for issue of sale orders for total quantity of 483,850 metric tons from various agencies and same are under consideration. That's why we had last occasion, let's reason directly to file counter, partial counter, for which I'm seeking time. On 17th, by 17th, I will file the counter stating that what is the state.
In the counter, they only noted 10 contracts.
That was there are subsequent developments.
This is very strange, and they are made.
And now even in the list also second paragraph, some are also willing.
Some
that's what we have. How many are there?
Who are there? Some.
The other
come to say there are only 13 bidders.
Yes, sir. 11 out of 13, 11 are come forward to lift this amount, this amount, and the other two are also willing to come.
Find out from your.
Yes, sir.
List some paid.
17.
Make it call to them.
17 people.
Make it call to them, sir.
No, I will call them, but we have